Welcome to Court C of today's proceedings. I am Judge President Bilangulo and I will be presiding over this courtroom alongside with Justice Nyago and Justice Pabo. And we'll be hearing your arguments today. We'll start with the applicant and then we'll hear arguments from the respondent and then court will go like that. I unfortunately cannot turn on my video because where I am, the cameras are not set up, but I can hear you and I can see you. And should there be anything else, I'm sure webcast support will be able to assist us in terms of signal and other issues. If we are ready, if there are no any other preliminary issues from Justice Nyago and Justice Pabo, we may begin. Is the bench ready?
Yes.
Okay. Team applicants, the floor is yours.
Congratulations to you, your justices. May it please the court. My name is Tepiso Masita, and I am counsel for the 6 learners from Jondolo Combined School. My co-counsel here is Ntabile Nkali. I will be addressing issues concerning Section 4 of the School's Code of Conduct, which violates my client's rights to education and privacy. Therefore, my co-counsel shall address the SGB's decision, which violates our client's right to peaceful assembly. I will take 9 minutes for my argument. Therefore, my co-counsel will also take 9 minutes for her argument. And 2 minutes has been reserved for the rebuttal. If I may submit the fact of the case with the justices. In 2019, Njondolo Combined School appointed Ms. Koza as the new principal to improve the situation of absenteeism and build discipline of both teachers and learners. She did this by conducting a new code of conduct after consultation. The new code of conduct introduced a new rule of the confiscation of cell phones whenever found in the school's premises. Therefore, there was a usage of corporal punishment which was implemented unconstitutionally by the educators in terms of Section 10 of the South African Schools Act. If I may submit my case, the justices. In terms of Section 2 of the Constitution, it states that the Constitution is the supreme law of the country. Therefore, any law that is in conflict with it is declared as invalid. Proceeding to my case, the justices. The school violated my client's rights to privacy when they searched and seized their private belongings in terms of Section 14, subsection B of the Constitution. They went on to violate Section 14, subsection D of the Constitution when they went through my client's WhatsApps. And the Constitution clearly states that no one should have the rights to privacy of communications infringed. Referring to the Geithner's case, justices. The Geithner and others versus Auction Alliance in 2013, as recognized by Roger J, paragraph 91. It states that warrantless search operations in the absence of consent urgency on private property based on suspicion constitutes an unjustifiable violation to privacy. This case was implemented by the High Court, was ruled by the High Court. Therefore, we request that the Constitutional Court takes this into consideration or pursue the case. The SGB just searched without legitimate reasons and legitimate documentations. And also, the code of conduct does not give them provision to conduct random searches. They also violated my client's rights to education when they suspended them for a prolonged amount of time.
Sorry, counsel. I'm sorry to interrupt. Would you say that the Bill of Rights, the rights in the Bill of Rights, are absolute, so they cannot be limited under any circumstances?
They can be limited if it's reasonable and justifiable in terms of Section 36 of the Constitution.
Okay, thank you. You may proceed.
They violated Section 29 of the Constitution by limiting my client's rights to education. And they did this by suspending my clients for a prolonged amount of time, whereas the South African Schools Act, Section 9 of the South African Schools Act firmly states that no learner should be suspended for a period longer than 7 days, pending a disciplinary hearing. The Section 28, subsection 2 of the Constitution states that a child's best interests are of paramount importance, and this suspension was not in any learner's best interest. If there are no more questions, Your Justice, I would like my co-counsel to finish up the argument. May it please the court.
To you, Your Justices. May it please the court. As my co-counsel here has stated that my name is Ntabile Nkabi, and I'll be addressing the SGB's decision, which is unconstitutional and violates my client's right to peaceful assembly in terms of Section 17 of the Constitution. Adding on to the facts of the case, Your Justices. Your Justices, the school conducted a raid and a few cell phones were found, of which the owners are my clients here. They were suspended immediately without undergoing any disciplinary hearing. They were told to leave the school's premises, and they did, thereafter standing outside the school's premises. The school bell rang for the end of the day, and the other learners decided to join my client here, discussing the unfairness of the situation. A spontaneous protest was staged. The police came and told my client here that it was an illegal gathering, as notice had not been given. One of my clients tried explaining that the group had formed spontaneously, so notice had not to be given. We submit as follows. In terms of Section 2 of the Constitution, the Constitution is the supreme law of the country. Any law or conduct that is in conflict with the Constitution, it is invalid. We acknowledge the fact that the respondents implemented a code of conduct after a consultative process with the parents and the learners. However, for as long as it is in conflict with the Constitution, it is invalid. Section 9 of the Constitution states that everyone is equal before the law and has the right to equal protection and benefit of the law. My clients here did not undergo any disciplinary hearing. They were suspended immediately after they found cell phones in their school bags. They did not benefit from the law, as they were treated unfairly by the respondents. My clients here have every right to challenge the constitutional validity of Section 4 of the School's Code of Conduct. Furthermore, Section 17, Act 108 of 1996 of the Constitution provides for the right to peacefully and unarmed to demonstrate, picket, and to present petitions. It's clear that the applicant's protest was peaceful and within the confines of the law. Therefore, the respondent's conduct is unconstitutional, not forgetting that the gathering was spontaneous. With the Sotau v. Gavus case, paragraph 52 states that everyone who is unarmed has the right to go out and assemble with others to demonstrate, picket, and to present petitions for any lawful purpose. This then justifies the applicant's protest as they were unarmed. The rights in the Bill of Rights may be limited only in terms of general application, to an extent that the limitation is reasonable and justifiable in an open democratic society based on human dignity, equality, and freedom, taking into account all relevant factors in terms of Section 36 of the Constitution. The respondents therefore limited my client's right to education and The respondent's conduct is not a general law of application, as it is not in accordance with Section 36 of the Constitution. We finally submit that the applicant's right, as pre-mentioned, cannot be said that they can be limited, in that the respondent's code of conduct is not a general law of application. It is unconstitutional and as not in accordance with Section 36, Act 108 of 1996 of the Constitution. We thus request the court to dismiss Section 4 of the school's code of conduct and that the respondent's case is unconstitutional as it is not in accordance with Section 36 of the Constitution. Thank you.
Counsel, before you rest your case, what do you think would have been an appropriate response from the school governing board? Since you say that what their conduct was an overreach and a violation of the rights of your client, what is your suggestion that would have been the appropriate thing to do?
I can't hear you, sir.
In what context would the school governing board have acted in a way that would have protected the rights of your clients?
Did you repeat the question, Your Justices?
So your argument is that the governing board was wrong in instituting those particular rules. What do you think would have been a fair rule in terms of the regulation of cell phone use in school? Should they have restricted access only outside the classrooms, or was there a way that they could have managed this without causing, the kind of anger that was caused among the students?
Well, they could have suspended the learners. They could have let the learners undergo a disciplinary hearing before suspending them for the rest of the year.
Yes, but do you have a problem with the prohibition of the use of cell phones in itself?
Yes, because they prohibited the use of cell phones. However, they found the learners with the cell phones and they confiscated them, and they still suspended them for the rest of the year without undergoing any disciplinary hearing.
Okay, counsel, I think you may continue with your argument.
We're done, Your Justices.
Counsel, are you done with your submissions?
Yes, Your Justices.
Thank you so much, team applicants. We may now hear team respondent.
May it please the court. My name is Sam Stanov and I'm with my co-counsel Ritabile Mulan, and we appear on behalf of the respondent. The question before the court is whether the applicant's right to privacy and basic education has been violated by the implementation of Section 4 of the School's Code of Conduct or not, and whether the SGP's decision has violated the applicant's right to peaceful assembly or not. We submit that the applicant's rights stated in Section 14, 17, and 29 of the South African Constitution were not violated, and that Section 4 of the School's Code of Conduct is not unconstitutional. Counsel for the respondent therefore argues in line with Section 24 of 2005, South African Schools Act number 84 of 1996, and the case of the head of Department of Education, Free State Province, against Welcome High School. We submit that the respondent acted legally. In this case, I will be responding in matters concerning Section 4 of the School's Code of Conduct and Section 14 of the South African Constitution. And my co-counsel will respond in matters concerning Section 17 and Section 29 of the South African Constitution. Section 4 of the School's Code of Conduct is not unconstitutional. South African Schools Act number 84, Section 8, subsection 1, explicitly states that the SGP of a public school must adopt a code of conduct after consulting with the learners, parents, and educators of the school. We submit that the respondent did go through a consultative process, and by the majority's will, the code of conduct was implemented. In South African Schools Act number 84, Section 8, subsection 2, and the judgment that was given in the case of the head of Department of Education, Free State Province, against Welcome High School.
Counsel, What happened in that case that you just quoted? And how is it relevant in today's proceedings?
What happened in the case that the SGP implemented a code of conduct that prohibited any female that is pregnant from attending school. The Free State Health Department instructed the public school to avoid or to ignore the learner pregnancy policies that are adopted by the SGP and reinstate the learners who were suspended. The court held that the SGP has a right to adopt a code of conduct as stated by the South African Schools Act number 84 of 1996. The HOD did not have the authority to tell the principal to go against an adopted policy of the SGP. And now the applicants could interfere with decisions of implementing a code of conduct. The relevance with the case is that we are trying to prove the constitutionality of the code of conduct. Hence, it was designed according to Section 8 of the South African Schools Act number 84 of 1996.
I think you may proceed, Council.
It was stated that the school must. It was stated that the school code of conduct must be aimed at establishing a disciplined and a purposeful school environment, dedicated to improving and maintaining the quality of the learning process. In this case, the SGP implemented the school code of conduct after analyzing what is best for the school and learners, and how the code of conduct can assist in improving the academic performance of the learners. All in all, we can proudly say that the code of conduct was aimed at improving and maintaining the quality of the learning process. The use of cell phones in the case of the applicants was clearly inconsistent with maintaining the quality of the learning process. Hence, they were improperly used. If the applicants are valuing the use of cell phones more than education, then that precisely means that they are the ones who are limiting their right to basic education and quality education. The SGP fulfilled their duties stated in Section 20, subsection 1H of the South African Schools Act.
Before you proceed, let's say we agree that the use of cell phones can be destructive to the learning environment. How do you justify not just the use, but the prohibition of cell phones altogether? It cannot even be in your possession, whether or not you are using it. Is that not perhaps going too far in regulating people's privacy and what they can have in their possession?
Can you please repeat your question?
How do you justify the complete prohibition of cell phones? It's not only about the use of the cell phones. Now the school wants to even prohibit the mere possession of the cell phone, whether or not the learner is using it. Is that not a rule that goes too far?
No, the improper use of cell phones can negatively impact the learner's behavior. Learners, especially who are addicted to using their cell phones, will be tempted, if their cell phones are off, will be tempted to turn on and use their cell phones. That will make the students not to focus on the lesson, rather to focus on how to turn on their cell phone without being seen. So it was best to completely ban cell phones from school.
You may proceed, Council.
Okay. The SGP fulfilled their duties stated in Section 20, subsection 1H of the South African Schools Act by promoting the best interest of the school and learners, and also ensured development in provision of quality education. Section 14 of the South African Constitution states that everyone has the right to not have their property searched, their possessions seized, and their privacy of communication infringed. Section 7, subsection 3 of the South African Constitution states that this right is subjected to limitations stated in Section 36, generally known as the limitation clause. In the case of Ministry against Interim Medical Council of South Africa, the Constitutional Court stressed out that the right to privacy, like all other rights, is not absolute, as stated by Section 36.1, Section 36, subsection 1 of the South African Constitution, that all the rights listed in Chapter 2 of the Constitution are not absolute, but may be limited in certain circumstances. In some instances, it is reasonable and justifiable for the society to intrude into the personal and privacy realm of an individual. If therefore the school wishes to search learners periodically in order to detect and prevent forbidden items from accessing the school, then that must be done so in terms of the legislation. In this case, the search and seizure was done with intentions of maintaining a proper order and discipline, and also to promote proper learning quality. We also submit that the search and seizure was done under reasonable suspicion. Hence, the school believed that the learners might be having their cell phones with them after the incident of Mr. Kwele. The phone of Mr. Kwele fell out of his pocket and was seen by a teacher and was confiscated. Throughout the search, the evidence that support the suspicion of the school was obtained. By bringing cell phones to a school, while knowing that they might be confiscated, the applicants were risking and willing for their cell phones to be confiscated. If the court doesn't have any questions for me, then I would love to let my co-counsel to proceed from where I left, if you please the court.
Thank you, counsel. I think the bench is satisfied, they don't have any question, we may proceed to hear the second speaker.
May it please the court. My name is Retabile Molawa, as introduced by my co-counsel. Section 17 of the Constitution of South Africa states that everyone has the right to assemble peacefully, to demonstrate, to picket, and to present petitions. In this case, counsel for the respondent does not deny that the applicants were armed when protesting. However, not only did they not practice their right to peaceful assembly, they also vandalized the school's property by setting the administration block on fire and a trash bin next to the teacher's car park on fire. Attacking the school's property violates the rights stated in Section 29 of the South African Constitution, which states that everyone has the right to basic education, including adult and further education, which the state, through reasonable measures, must make progressively available and accessible. We submit that any student who vandalizes the school's property must be held accountable for their action and must be subjected to disciplinary hearing, including possibility of suspension and expulsion from the school's activities. According to Section 9 of the South African Schools Act of 1996, the SGB has every right to suspend a learner after following the correct procedures.
Counsel, what does that section say?
It says, the SGB of a school may, on reasonable grounds and as a precautionary measure, suspend a learner who is suspected of serious misconduct from attending the school.
Okay, you may proceed.
In this case, we submit that the school followed the correct procedures by hosting a disciplinary hearing where the applicants were found guilty of vandalizing the school's property and violating Section 4 of the school's code of conduct. The SGP conducted the disciplinary hearing in a manner that is contemplated in Section 8 against the applicants. It should be expressed that suspending the learners was not in intentions of violating the right to basic education. However, it was in intentions of instilling discipline within them, and that was done legally. In conclusion, counsel for the respondent argued in line with Section 9 of the South African Schools Act of 1996, South African Schools Act number 84 of 1996, and the case between Head of Department of Education, Free State Province against Welcome High School. We also argue that Section 4 of the school's code of conduct is not unconstitutional, and Section 14, 17, and 29 were not violated. Furthermore, we stated that Section 4 of the school's code of conduct was designed according to South African Schools Act number 84 of 1996. The respondent acted in consideration of what is best for the school and learners legally. Counsel for the respondent therefore requests this honorable court to declare that Section 4 of the school's code of conduct is not unconstitutional and does not violate the applicant's right to basic education. Secondly, to rule that the SGB's decision is not unconstitutional and does not violate the applicant's
Counsel, what do we use to determine that something is constitutional or unconstitutional?
Generally, we use the Constitution, the Bill of Rights.
Okay, so if it's written in the Constitution, it means it's unconstitutional. It's constitutional, and then if it's not, it means it's unconstitutional.
Yes, Justice.
Okay, thank you. You may proceed.
Lastly, to give a verdict that states that the applicants violated the rights stated in Section 29 of the South African Constitution by making it impossible for other learners to access the school and by violating the school's property. If it pleases the court, I'd like to descend the podium.
Does the bench have any other question?
Nothing from me.
Justice Nyako?
No, I don't have any further questions.
Justice Papo?
I don't have further questions.
Would the applicant like to make rebuttals, or if they set out time for rebuttal?
Yes, we will be.
Okay. You may take the floor.
Your Justices, the respondents claim to have followed the correct procedures regarding the suspension of the learners. However, my clients here did not undergo any disciplinary hearing except for one learner from the school. They carried on to suspend the learners for the rest of the year, which was not in accordance of Section 9 of the Constitution, which states that no learner should be suspended for an amount of longer than 7 days. Furthermore, there's no proof that the admin block was set on fire by the applicants. The respondents went searching, went looking for the cell phones in the applicants' school bags, not searching. My co-counsel would consult the justices.
The justices, the respondents, I heard them. I want the respondents to justify the usage of the corporal punishment because Section 10 of the South African Schools Act states that no learner should be a victim of corporal punishment in the schoolyard. And the SGB did not have legitimate documentations to conduct the search. They were just suspicious. And they should see the phones in order to confiscate them. Because if the phones were in the bags or in the pockets, doesn't reasons to have phones with them, maybe to communicate with their parents or maybe to like and therefore as not
Thank you, counsel. Thank you so much, the applicant and the respondent, for your submissions. Court is adjourned and you may leave the room and the judges will be left to deliberate. Thank you so much.
Good morning, everyone. Welcome to today's National Schools Mood competition session. I'm Khomela Letswalo, and I'll be the presiding judge for this session, together with Justices Lobola and Motokwane. And if I may ask the teams to provide their names before we begin the session. In the chat box, they can type their names in the chat box and indicate who's going to be the first speaker and the second speaker. Thank you, applicant. Can a respondent also do the same by indicating their surnames in the chat box and indicate who's the first speaker and who's the second speaker? And while applicant is doing that, and I think that, while respondent is doing that, then I think that applicant can also indicate how many minutes they'll be taking per each speaker, so that we are able to time them appropriately. Applicant, you can just say it out loud, and then I'll write it down so that I'm able to time you guys appropriately, depending on how much time you'll be taking per speaker.
For the first council, it's 11 minutes. And
Okay.
for the second council, it's 7 minutes. And then we leave 2 minutes for rebuttals.
Thank you, counsel for applicant. And respondent.
As it pleases the court, my name is Nsmcc, and together with my co-counsel, Liteta Njongwe, are appearing on behalf of the respondents. If it pleases the court, I'll be using 12 minutes of this court's time, and my co-counsel will be using 8 minutes, as it pleases the court.
And how many minutes are you reserving for rebuttal? Oh, there's no rebuttal. I apologize for that. I seem to always mistake that fact. So before we begin the session, I also want to make you aware that I have created some time cards. So while you are speaking, I'll try to indicate the time that you have left through time cards. So you can just look at the screen to pay attention to what time you have during the duration of the session. And I think that is we've received all of the information that we need to start this session. And the first speaker on behalf of the applicant can approach the bench and make their submissions.
If it may pleases the court, I am Azande Smelane alongside with my learned co-counsel Mandisa Sole, and we are the representatives of the applicant. Your Justice, there are 4 issues before the courts today. The first issue being the unconstitutionality of the Code of Conduct, which violates the learner's rights to freedom of expression, Section 16 of the Constitution, and to privacy, Section 14 of the Constitution. The second issue before the courts today is the suspension of the learners, which violates their rights to basic education as stated in section 29, subsection 1 of the Constitution. For the first 11 minutes, I will be arguing these issues I have stated. And furthermore, my learned co-counsel, Mandisa Sithole, will argue on how the respondent violated the learners' rights to peaceful assembly and the rights to freedom of association for 7 minutes. And we are going to leave 2 minutes for rebuttals. The first issue presented before the courts is the unconstitutionality of the Code of Conduct, which violates the learners' rights to freedom of expression as stated in section 16 of the Constitution, which says, everyone has the rights to freedom of expression, which include the freedom of press and media, the freedom to receive or impact information and other ideas, the freedom of artistic creativity, and the freedom of academic and freedom of scientific research. Section 16B of the Constitution states, everyone has freedom to receive or impact information or ideas. On the set of facts, paragraph 8, we find that the learners formed a group spontaneously to impact information on how harsh they thought the Code of Conduct was, which was a clear practice of their rights to freedom of expression as stated in section 16 of the Constitution. Furthermore, the violation of the rights to privacy as stated in section 14 of the Constitution that everyone has a right to privacy, which includes their rights not to have their person or home searched, their property searched, their possessions seized, or the privacy of their conversations infringed. The issue to search their possessions, in this case, their school bags, was without prior notice, especially since it was without their permission. Section 14B of the Constitution guarantees a person's rights to privacy, specifically not to have their property searched. Property includes movable and immovable property. The concept of immovable property in this case is their cell phones, which cannot be restricted only to their home. Thus, the workplace and the school place will be protected under Section A and Section 14B.
If I may ask, you stated in your previous submission just now that the learners were not given any. Paragraph 6 of the facts, it says that he confiscated within the next day after Sfiso Cele's phone is discovered. Would that not constitute a warning for the learners?
Can your Justice please repeat the question?
I will, counsel. Paragraph 6 of the facts says that Ms. Koza tells the students that after they discover a cell phone in Sfiso Cele's bag, she tells the students that on the next day, any cell phone that is on or off will be confiscated. And would that not constitute a warning? As you said that they were not warned, would that not be a warning of some sort for them to not bring phones because they know that they will be searched and any phone that they see will be taken?
Your Justice, it was a warning, but I would like to bring it to the court's attention that the learners did not think that the search will be on the following day.
You may proceed, counsel.
Thank you. Even the search and seizure, Your Justice, there has to be relevant authority. I do not think a school is a relevant authority to conduct a search and seizure because even they have to get a warranty to search and the school did not have any relevant authority. Even so, it is limited in terms of Section 36 of the Constitution. So, Your Justice, someone must prior authorize to conduct the search and seizure. The Code of Conduct may have been properly promulgated through the participation of the SGB, the school, the parents, and the learners. but the implication of it is too broad as it leads to the violation of certain constitutional rights, such as the rights to privacy and the rights to freedom of expression, as I stated.
Yeah, now you can go ahead.
Thank you. So if I understand correctly, you're saying that the whole school's code of conduct is unconstitutional, or are they against a specific section?
Section 4 of the school's code of conduct, Your Justice.
Thank you.
The code of conduct was too broad as it violated the learner's rights to privacy and freedom of expression.
Counsel, if I may also ask you a question. You mentioned limitations in respect of Section 36 of the Constitution. So don't you think that those limitations also apply to the rights that the learners have, particularly the right to privacy? Don't you think that that right can also be limited, especially in the context of school, as phones can also be a distraction? Don't you think that then the schools can limit that right by searching for phones that would distract students and taking them from students and punishing them appropriately? Would that not be a limitation to that right?
Your Justice, the rights to privacy extends to not only to our homes, but also to the workplace and the school. So the learner's rights to privacy is protected under Section 14A and Section 14B of the Constitution. The Schools Act number 84 of 1996, Section 8, subsection 2, and the case of MEC for Education versus Pillay 2007, a constitutional case, states that the purpose of a code of conduct must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and the maintenance of the policy of the learning process. We do not argue, Your Justice, that the learning process has increased and discipline has been maintained in the school. But the question that is left before the courts is the way that they maintained their discipline, was it constitutional for our clients? Furthermore, we submit that according to the supremacy clause of Section 2 of the Constitution, Section 4 of the Code of Conduct is invalid. The clause of supremacy states that no rule or conduct can be inconsistent with a constitutional rule, and if so, it is invalid. Since Section 4 of the School's Code of Conduct violates the learner's rights to basic education in terms of the suspension, it is invalid. The second issue before the courts is the suspension of the 6 learners which violates their rights to basic education. Section 9, subsection 2 of the Schools Act reads as follows. A learner at a public school may be expelled only by the head of department and if found guilty of misconduct after disciplinary procedures. I'd like to bring it to the court's attention that in this case, since their suspension was more than 7 days, it was sent to be an expulsion, and it was not made by the head of department. And they were not found guilty of a serious misconduct, since bringing a cell phone at school is not a serious misconduct, because in terms of serious misconduct, we have to count bringing drugs to school and dangerous weapons, and bringing a cell phone to school is not a serious misconduct. On the set of facts, paragraph 6, it states that the learners are suspended by the principal, and the fact that they were suspended with immediate effect without a disciplinary hearing, which would have given the learners a platform or a chance to justify their actions. All the facts on paragraph 6 violates or infringe Section 9, subsection 2 of the Schools Act. If it may please the court, I would like the courts to consider a previous case which was presented at the very same court. The head of Department of Education, Free States versus Welcome High School, and another in 2014, paragraph 46, which states, the Constitutional Court stated that the precautionary measure, a governing body may suspend a learner for up to 7 days, pending his or her disciplinary hearing, or for such a longer period of time as an HOD authorizes. The governing body, in the event of the learner having committed a serious misconduct, disciplinary situation for up to 7 days of the suspension only by the HOD, and which may decide to expel a learner. If it may pleases the courts, may we please add 1 minute?
I will give you a minute, Council, to conclude your submissions.
Thank you. In this case, the learners are suspended by the SGB and not the HOD, even for a longer period of time and not for 7 days. In the same welcome case, paragraph 82, the court stated that the Schools Act does not empower a governing body to expel a learner or to suspend him or her for a lengthy period of time. The lengthy period of time infringed the learner's rights to education. Furthermore, it is not justified as in terms of Section 36E of the Constitution, which says limiting a certain right less restrictive in order to achieve a particular purpose should be applied. A less restrictive measure in this case should have been the confiscation of their cell phones and not the suspension. The school would have achieved this purpose of instilling discipline by confiscating their cell phones and not by suspending them. If there aren't further questions from the courts, I would like to hand over to my co-counsel.
Thank you, Council. Are there any questions from the justices?
None from my side.
Thank you, Council. None from my side.
Okay, thank you. Then if there are no questions, then the second counsel on behalf of the respondent may approach the bench. On behalf of the applicant, I apologize for that.
Justice, can I begin?
Yes, you may, Counsel.
If it may please the court, Justice, I'm Nsmcc Sithole. I also appear on behalf of the applicant. Justice, there are 2 issues before the court and to be decided today, of which I'll focus on. First is whether Section 4 of the School's Code of Conduct is unconstitutional, and secondly is whether Section 4 of the School's Code of Conduct allows the infringement of Section 4 of Section 14 and Section 29 of the Constitution. Justice, we submit that the respondent had violated the applicant's right to demonstrate in terms of Section 17 of the Constitution, which states that everyone has the right to peacefully and unarmed protest, to assemble, to demonstrate, to picket, and to present petitions. According to paragraph 1, page 3 of the set of facts, it is stated that the 6 learners of Mjondolo High School did not use violence when they were protesting. They just stood as a group. I would like to discuss into a case between Satau versus Gavas in year 2013 from a constitutional court. Paragraph 52 states that everyone who is unarmed has the right to go out and assemble with others, to demonstrate, to picket, and to present petitions for any other lawful purposes. Justice. In addition, there is no way in the set of facts that the learners perpetrated violence in the protest. In the same case, Justice, in paragraph...
Does it not matter that the students dragged bins in front of the school and that at a later point there was a fire set?
You do not argue the fact that the learners burned the bin in front of the school's gate, but the convener of the gathering could not foresee that the joining or the involvement of other learners into their process would lead to such an act. Can I proceed, Justice?
Yes, thank you.
Justices. In addition, there is no way in the set of facts that the learners perpetrated violence in their protest. In the same case, Justice, in paragraph 53, it is stated that the requirement that the right in Section 17 must be exercised peacefully, and the right to assemble is central to our constitutional democracy. and it includes groups that do not have political and economical power and vulnerable persons. We submit that the protest was started spontaneously as stated in the set of facts, page 3, paragraph 1. The learners did not have time to give not adequate notice to the police to ensure a well-structured protest with enough cohesion. Hence, it was started under the sense of agency. But nevertheless, Justice, no violence was applied to their protest. I would also like to refer this. Yes, Justice.
If I may ask, you do say that the protest was formed spontaneously, but wasn't that the first protest? There was actually a second protest the next day where the students actually planned the protest and they went out for the protest. They blocked students from accessing the schools, and there was even an instance where a fire brigade was called. Could you not say that these are two separate issues which must not be conflated together?
On that regard, Justice, the number of the learners was less than 15, so there was no need to issue notice to the police in that regard. Can I proceed? I would also like to refer this court into a case between Mulungwana and others versus the state and others in year 2019, and was also a constitutional court case. In paragraph 16, it is outlined that it can be a criminal offense if a gathering is started spontaneously. But the court stated that it is open to a convener to invoke defense if the gathering consent took place spontaneously. Furthermore, Justice, we submit that the school did not only violated Section 17 and other sections claimed by my co-counsel, but they also administered corporal punishment. We submit that the use of corporal punishment in our school is a prohibited act in terms of Section 10 of the South African Schools Act policy. I would like to refer this court into a case between Christian Education South Africa versus the Minister of Education in year 2000, also a constitutional case. Where the Constitutional Court stated that corporal punishment amounts to total lack of respect of human being, and it remains the invasion of dignity of the students. That was paragraph 46, according to this case. The use of corporal punishment also resulted in the protest that was started spontaneously. In terms of Section 39, subsection 1b of the Constitution, which deals with the interpretation of Bill of Rights, it is stated that when interpreting a Bill of Rights, the court must consider international law. In terms of Article 21 of the United Nations International Covenant on Civil and Political Rights, in short ICCPR, it is stated that the right to peaceful assembly shall be recognized. Ultimately, in terms of Article 15 of the United Nations and Convention of the Rights of a Child, in short, CRC, it is clearly stated that state parties must recognize the rights of a child to assembly. I submit that South Africa ratified both of these treaties and agreed to bound upon its provisions. Everyone has the right to assembly freely with others, according to the Article 8 of the African Charter, on this right, on the right of and welfare of a child. Justice. This course has to take into account the issue of Ubuntu. Ubuntu has become an integral part of our constitutional values and principles, in form of interpreting a Bill of Rights and other areas of law. In the matter between us and Mungwaka in 1995, a constitutional court, the court stated that Ubuntu is an integral part of our constitutional value, and it also calls for reconciliation. When Ms. Koza sent the text message calling the learners to come so that it could have a meeting, she into the spirit, she did not use the spirit of Ubuntu as wanted to recognize the parties reconciled. Justice, we submit that Section 4 of the School's Code of Conduct is unconstitutional and violates the learner's right to privacy and basic education in terms of Section 14 and Section 29 of the Constitution.
Thank you, Justice. Thank you, Counsel. I think your time has elapsed. Thank you for your submissions. And are there any questions from my fellow justices?
None from my side.
Okay, no questions my side. Thank you, Counsel.
Thank you. Okay, thank you, Counsel, on behalf of the applicant. Thank you for your submissions. We will now proceed to the Counsel for the respondent. May the first Counsel on behalf of the respondent please approach the bench.
As it pleases the court, to remind the court, my name is Nsmcc, to deliberate on the first issue. That is, that Section 4 of the School's Code of Conduct is constitutional and not in violation of the learner's rights to basic education in terms of Section 29 of the Constitution. It is also not in violation of their right to privacy in terms of Section 14 of the Constitution. My co-counsel will argue the second issue, that the SGB's decision to suspend the learners is not in violation of their right to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the court, may I please address the first issue. After the applicants were found in possession of cell phones which contravene Section 4 of the School's Code of Conduct, these cell phones were seized and thereafter they were suspended. As counsel for respondent, we submit that the suspension of the learners is not in violation of their right to basic education in terms of Section 29, subsection 1 of the Constitution. Section 29 of the Constitution provides as follows: everyone has the right to basic education, including adult basic education. Your Justices, as counsel for applicant, we submit the case of Head of Department of Education, Free State Province, Welcome High School, and another. Head of Department of Education, Free State Province versus Harmony High School, and another. 2014 CC SA 228. At paragraph 205, it was stated that the right to basic education can only be limited in terms of law of general application, in accordance with Section 36 of the Constitution. As counsel for respondent, we submit that the South African Schools Act is a law of general application, and it allows schools to establish a school's code of conduct for the betterment of the learning process and its maintenance, and to enforce discipline. Our learned friends pointed out that the limitation of their right, of the applicant's rights to basic education is not justifiable. As counsel for respondent, we submit that that is not so. We submit that it is justifiable. The suspension stipulated in the school's code of conduct applies to every learner in the school. It does not pick out certain individuals. It is a punishment.
Counsel, while we appreciate your argument that it does not discriminate against any learner, do you think that the suspension period itself, it is stated here that as Fisotele is suspended for a year, do you think that that suspension is reasonable? Is it a reasonable suspension period?
As it pleases the court, as counsel for respondent, we submit that the facts are not clear on the period of the suspension. It only stated that the learners and Swisotele were only suspended for the rest of the year. We cannot say if it was not 2 days before the final closing of the school day of that year, as it pleases the court. If it pleases the court, if there are no further questions, may I please continue with my submission? As counsel for respondent, we submit that the suspension stipulated by the school's code of conduct is a less restrictive means of ensuring that there is discipline at the school. To support this, in the facts, it was stated that both learners and teachers agreed that there was a greater need for discipline at the school, and that learners were punished even for the smallest transgressions, and there was much resistance against the new measures. We submit that by implementing the school's code of conduct, these restrictions were tarnished, and the less restrict and these smallest trends, it made sure that all parties involved had a common resolution, that is, discipline is enforced in the school, and that people who contravene Section 4 of the school's code of conduct are punished. As it pleases the court, the counsel for applicant also pointed out that the learners were expelled, and that in such an event, the head of department needs to be present. As counsel for respondent, we submit that that is not true. The learners were not expelled, they were only suspended. And in the facts, it was stated that the learners were suspended for a maximum period. And we submit, your justices, that a maximum period is 14 days. It is a period of 14 days. Furthermore, your justices, we submit Section 8, subsection 1 of the Schools Act, which states that subject to any applicable provincial law, a governing body of a public school must adopt a code of conduct for the learners after consultation with parents and educators of the school. Therefore, as counsel for respondent, we submit that when the consultative process was called, when the parents of the learners, which we will assume that were part of this consultative process, when the representative council of learners was also present, it made decisions on behalf of the learners for their own best interests. When they agreed to its immediate implementation, they were bound to obey it, and that they were bound to a suspension if they were found in possession of cell phones. Your justices, subsection 2 of the Schools Act states that a code of conduct referred to in section 8, subsection 1 must be aimed at establishing a disciplined and purposeful environment dedicated to the improvement and maintenance of the quality of the learning process. As counsel for respondent, we submit that the school's code of conduct is in line with the aim it was established for. It was established to make sure that the school environment was not disrupted, that the learners' rights to basic education is honored, and that they all receive their right to basic education in a safe environment where there are no disruptions, and that the teaching time is productive and the learners can gain knowledge. If it pleases the court, may I please proceed to the second argument. The applicants were searched and found in possession of cell phones which contravened with section 4 of the school's code of conduct. Thereafter, they were seized. As counsel for respondent, we submit that the seizure of their cell phones is not in violation of their right to privacy in terms of section 14 of the Constitution. Section 14 of the Constitution states that everyone has the right not to have their personal home searched, their property searched, their possessions seized, or the privacy of their communications infringed. As counsel for respondent, we submit that our learned friends pointed out that the school needs a warrant to order for a search and seizure of cell phones. But as counsel for respondent, we submit that the school did not need a warrant as supported by the regulations to prohibit initiation practices in schools, which says under the Schools Act, which serves as a law of general application, which can limit the learner's rights to privacy. The Part 4 principles numbered 3.2.2 under this Gazette states that everyone has the right to privacy, which includes the right not to have his or her person or property searched or his or her possessions seized. Notwithstanding this, the principal or an educator may search learners based on his or her reasonable suspicion that the learner is in possession of an illegal object, using such methods that are reasonable in scope. Your justices, as counsel for respondent, we submit that cell phones are illegal objects for a learner to help in the school premises. Counsel for applicant also pointed out that in order for the Schools Act to permit for a search and seizure for cell phones, it has to fit under the definition of stupefying or intoxicating or illegal drugs. We submit that in this gazette, it was an illegal object was stated, and there was no definition of what an illegal object is. Therefore, since cell phones are in contravention of the Schools Code of Conduct, they can be searched for and seized for without a warrant. Furthermore, Your Justices, after Sfiso Ele's phone dropped out of his pocket, it raised reasonable suspicion for the principal to conduct a search. In this gazette, Your Justices, the condition of a warrant should be present in order for a search to be conducted has not been stated. Therefore, it is not needed as long as the principal has in her knowledge that there is reasonable suspicion that a learner is in possession of an illegal object, which are in this case cell phones, which are in contravention of Section 4 of the Schools Code of Conduct. Furthermore, Your Justices, as counsel for respondent, we bring forth Section 8 of the Schools Act. This subsection 4 of the Schools Act states that nothing contained in this act exempts a learner from the obligation to comply with the code of conduct attended by such learner. As counsel for respondent, we submit that the learners were subject to a search and seizure of cell phones if they were found in possession of cell phones, regardless of what the applicants put forward of what we can say the definition of an illegal object is. Furthermore, we submit that the cell phones had to be searched for and seized to prevent further disruptions or future disruptions. The school is not responsible for learner.
If I may ask, could the phones in this instance be construed as causing a disruption, as in the fact it does states that when these phones were found, they were Sfiso's phone drops out of his pocket, and in most instances these phones were off. So could you really say that they are disruptions?
As it pleases the court, concerning Sfiso case, the phone dropped out in class, and it is stated that in the facts, Mr. Nsmcc had to confiscate that phone. It was confiscated in class where education, the right to education is fully exercised. It means that the teacher had to stop whatever he was doing to pay attention to the cell phone that dropped. Furthermore, Your Justices, as much as the cell phones of the learners which were switched off were not disruptive, as counsel for respondent, we submit that the behavior itself of carrying a cell phone shows disrespect for the school. It shows disrespect for their right to basic education. Therefore, they were subject to a search and seizure as they displayed a rebellious behavior, adamant on breaking school rules. If it pleases the court, in conclusion of our arguments under the first issue, counsel for respondent submits that such. As it pleases the court, may I please have a minute to continue to finish on my submission?
Counsel, it's fine. I think we have heard your submissions, and there's no need for you to conclude. As I see that you are about to conclude, it's fine. I think that we've heard everything, and we will be able to deduce your conclusions. If we may have the next counsel on behalf of the respondent.
As it pleases the court.
To remind the court, I am Liteta Ndongwe, counsel for respondent. Your Justices, I'll be addressing the second issue, that the SGP's decision to suspend the learners is constitutional and does not violate the applicant's rights to peaceful assembly as detailed in Section 17 of the Constitution. Your Justices, the counsel for applicant pointed out that the SGP violated the applicant's rights in terms of freedom of association. Your Justices, as the counsel for respondent, we submit that it is not so. The applicants were granted the right to express their views through placards which were labeled cause for causa. Furthermore, Your Justices, Section 8 of the Gatherings Act, subsection 5 states that no person present at a gathering or demonstration shall, by way of a banner, placard, speech, or singing in any other manner incite hatred or other persons in any group of other persons or account the differences of sex, race, and language. Your Justices, we submit that the placards labeled "Cause for Causa" incited hatred. To support this, your Justices, it was in the facts whereby the fire went near the teachers' car park, meaning, your Justices, that the placards are the ones that incited the burning of the bins. Furthermore, your Justices, the counsel for applicant pointed out that they had the right to exercise a peaceful assembly in terms of Section 17. We agree, your Justices, but that must be done so in a peaceful manner. Your Justices, Section 17 of the Constitution states that everyone has the right peacefully and unarmed to assemble, to demonstrate, to picket, and to present petitions. The paramount conditions in this act, your Justices, are peacefully and unarmed. Your Justices, this right diminishes when these conditions are not met. Your Justices, as the counsel correspondent, we submit that the applicants' gatherings are not in accordance with Section 17, as these gatherings were unpeaceful. The counsel for applicant practiced several acts of unpeacefulness, which include them blocking the school gate, preventing other learners from entering through, which will make them able to exercise their right to basic education. Your Justices, if it pleases the court, as the counsel for respondent, we argue in line with the deliberations within the Satao and Another versus Gavas case. Paragraph 53 of this case states, and I quote, "Nothing said thus far detracts from the requirement that the right in Section 17 must be exercised peacefully. And it is important to emphasize that it is the holders of the right, in this case, your Justices, the applicants, who must assemble and demonstrate peacefully. It is only when they have no intention of acting peacefully that they lose their constitutional protection." Close quote. Your Justices, as the counsel for respondent, we submit that the applicants did not rightfully exercise their right to Section 17 because they did not meet the paramount conditions stipulated there, which were to remain peaceful. Furthermore, your Justices, if it pleases the court, the violence that erupted during the protests convened by the applicants violated the respondents' rights in terms of Section 12 of the Constitution. Subsection 1 of this section states that everyone has the right to freedom and security of the persons, which includes the right to, subsection C, to be free from all forms of violence from either public or private sources. Your Justices, as the counsel for respondent, we submit that the violence that occurred during their protest convened by the applicants did not honor this right. Your Justices, Section 3 of the Regulations of Gatherings Act 205 of 1993 states that a convener of a gathering shall give a notice in him by writing of the intended gathering. Your Justices, to remind the court that the applicants, your Justices, were not suspended because of the first gathering. They were suspended because of the second gathering. Your Justices, the applicants argue that the first gathering was spontaneous. Your Justices, as the counsel for respondent, we submit to this honorable court that even though the first gathering was spontaneous, the second and third gatherings were not spontaneous. Taking this into account, your Justices, the applicants certainly knew that they had the same common grievances as other school learners. Therefore, your Justices, the applicants could have foreseen that other people who had the same common grievances are going to join in the gathering, your Justices. Taking this into account, your Justices, this knowledge cancels the assembly as a demonstration and makes it a gathering of more than 15 like-minded people, an internal gathering that requires a notice. Your Justices, in summation, the SGP's decision to suspend the learners is constitutional as the learners practice several acts of violence. The violence perpetrated by the applicant's event even went further to obstruct other school learners from attending school. This prevented other learners from exercising their rights to basic education. In summation of both issues, your Justices, the cry from the applicants that the school prevented them from exercising their rights to privacy and basic education is unjust. We submit to this honorable court that the SGP's decision to suspend the learners is constitutional. As the counsel for respondent, we pray for the following orders. Number one, for the court to declare that Section 4 of the School Code of Conduct as a constitutional measure, as it does not violate the applicant's rights to basic education and privacy. Number two, for the court to declare that the SGP's decision to suspend the learners is constitutional and does not violate the learners' rights to peaceful assembly as detailed in Section 17 of the Constitution of South Africa. Number three, for this constitutional court to declare the High Court ruling as valid. And number four, for the applicants to be directed to pay the cost of this application together with the cost of the two councils. If it pleases the court and there are no further questions, I thank you.
Thank you, Council. If I may ask my fellow justices if there are any questions to be asked to Council.
None from my side.
Thank you, Council. None from my side.
Okay, thank you. If that concludes our respondents' submissions, if our applicant can approach the bench to make their rebuttal. And you reserved 2 minutes for rebuttal, applicant. You can begin.
If it may please the court, I am Nsmcc standing in for the applicant, and I stand in rebuttal and make the following points. Firstly, Your Justice, I would like the courts to take into account that in the matter between S versus Makwanyana, a 1995 constitutional court, which speaks on the account of Ubuntu, the reconciliation which Ms. Khoza made was after the learners' protest. So does that mean the learners had to protest in order for them to be heard and in order for Ms. Khoza to actually consider reconciliation? Where was the spirit of Ubuntu where she suspended the learners without a disciplinary hearing? The second point I would like to bring forth is a less restrictive measure in this case should have been the confiscation of their cell phones and not their suspension, especially for the rest of the year. And it is not taken as a suspension but an expulsion since it exceeds the 14-day rule. A third point I would like to bring into the courts is, according to Section 8A, subsection 1, which says random searches and seizure and drug testing tests at school are allowed only if there are suspicions of dangerous weapons and drugs. And in this case, cell phones are not dangerous weapons and they are not drugs, but they are just a set of communication. And the third and the last point I would like to make is the counsel for respondent is misleading the courts when he says that there were 3 gatherings. There were only 2 gatherings. There was no third gathering. Thank you.
Thank you, Council. And that concludes that concludes our session. Thank you to both parties for making their submissions. And now, if I may ask my fellow justices if they have any points of feedback to give to the Council.
Well, I'd like to thank the teams for their submissions today. There was great delivery. I liked the submissions and it showed great preparation and research. And overall, I don't think I can critique each one of them because I found it to be good considering the level that they're at. And yeah, thank you.
Thank you.
I share the similar sentiments. You both teams represented themselves very well. You guys have a very bright future ahead. So well done to both teams.
Thank you, Justice. Now I'll offer my own feedback. I think that both teams were really great. Both teams were really confident and they were really, you could hear by the voice, everything was audible and there was great eye contact. The question and answering, the questions asked were answered properly and there was good use of authority. Case law was used, international law was used, which is great. And yeah, I echo my fellow justices' sentiment that you have a bright future ahead of you. And I think that concludes the today's session. And if there isn't anything more, then both teams can exit the courtroom so that the judges may deliberate. Thank you.
Thank you.
How many minutes? Nine. Oh. And then second speaker. See, Bua Falke.
Cecile got S.
How many minutes?
9.
9. No, is it 2 minutes?
Have fun. Enjoy and give it your best.
Since your applicants, I apologize for that. So you reserve 2 minutes for rebuttal, right? Is that it? Since you're taking 9 minutes each.
Yes.
Okay, thank you. Sorry, I thought the other team was the applicant. Sorry. Okay, it's 10:30, and I think that we can begin the session. Applicant, I'm not sure if your camera is on or what, but we can. Yeah, we're able to.
Yeah,
see.
it's on. The camera is on.
Okay. Then, can the other justices see the participant, or is it just like from my side?
No, we can't see the applicants. Okay, now. Yeah.
Okay. Okay, yeah, I also can see them now. Okay, it's 30:30, so we can begin with the session. Before we start, I just wanted to notify you that I have time cards here. So when you're speaking, I'll just put this time card on the screen to show you how much time you have left. And please, take that into consideration and don't speak over your time. And secondly, I think that's it with the time cards. And I would like to welcome you to this session of the National Schools Mood Competition. I would like to welcome all of the teams. My name is Khomela Letswalo, and I'll be the presiding judge for this session. I'm here with my fellow justices, Motokwane and Mashilo. And we can proceed with the session, and the first speaker on behalf of the applicant can approach the bench and make their submissions.
Clearly understood. Thank you, Justice. I am Nsmcc, the representative of the applicants. We start with my argument. The issue before the Constitutional Court is whether Section 4 of the Schools Code of Conduct is unconstitutional and violates the learner's rights to privacy and the right to basic education. Counsel for the applicant contends that the Section 4 of the Schools Code of Conduct, counsel of the applicant contends that Section 4 of the Schools Code of Conduct violates the learner's rights on the merits that the principal of Mjondolo Combined School ordered the search of the learners' bags. 6 cell phones were found and 3 of them were off. The 6 owners of the cell phones were immediately suspended for the rest of the academic year. Thus, the applicant's right to basic education has been violated. Counsel for the applicant in this matter argue in line with Section 14 and 29 of the South African Bill of Rights. The nub of the case is centered on whether Section 4 of the Schools Code of Conduct, which states the following: the use of cell phones, whether on or off, in school premises by learners shall at all times be prohibited. Any learner found in possession of a cell phone may have that phone confiscated and may be suspended, is infringing the rights to privacy and the right to basic education. The letter of the case is a protest that has resulted from the above mentioned unconstitutional search and suspension of the applicant. The question is whether the applicant's right to peaceful assembly has been violated. They were suspended and detained for gathering and discussing the unfairness of Section 4 of the School's Code of Conduct. Counsel of the applicant in this matter consequently argue in line with Section 17 of the Constitution, South African School Act number 84 of 1996, on the case of the SGB, that the respondent has violated the applicant's right to peaceful assembly. Honorable Justices, according to Section 14 of the South African Bill of Rights, each and everyone has the right to privacy, which includes the right not to have their home searched or their possessions seized. The principal ordered a search of the learner school bags, which contravenes Section 14. It is the applicant's contention that Section 4 of the School's Code of Conduct contains two parts which are distinct and contradictory. The first part is prohibition that states that the use of cell phones, whether on or off by learners in school premises, shall be prohibited.
Counsel,
Yes, Honorable
you
Justice.
speak of Section 14 being contravened. Is Section 14 an absolute right that cannot in any way be limited?
Yes, Justice.
Thank you.
Thank you, Justice. May I continue? The court is humbly directed to take note of the following. Applicants had cell phones which were switched off and cannot be used in that state. The court be made to speculate whether prohibition relates to switch on or off or a possession of a cell phone. We will therefore argue that this part of the Section 4 of the School's Code of Conduct be omitted and declared unconstitutional by the Honorable Court, as it is ambiguous and posed as a general statement. The second part is prohibition, possession part. We also humbly direct the Honorable Court to take note of the following. Unless our learned friends want to argue it differently, it is our understanding, however, that possession means holding a cell phone in one's hand. We argue extensively that that was not the case with our clients, as their cell phones were in their school bags and respectively switched off.
Counsel.
Our case is that applicants had cell phones which were, yes, Justice.
Apologies to interrupt you mid-sentence, but in considering the way you're making the submissions, is Section 4 itself then inherently, is it unconstitutional, or is it the way the school sort of conducted themselves regarding Section 4? Where is the unconstitutionality?
Section 4 of the School's Code of Conduct is unconstitutional because it has suspended my clients for the remainder of the academic year, and they've conducted a search which contravenes their privacy.
Thank you, Counsel.
Thank you, Chief Justice. May I continue with my speech? Our case is that the applicants had cell phones which were not physically available as they were in their school bags, turned off, and cannot be used in that state. The conditions or grounds therefore do not warrant any confiscation or suspension of my clients. We contend therefore that this cannot result in confiscation and suspension of the complainant. We also direct the Honorable Court to Section 36 of the Constitution, which is a limitation clause, and ask whether the school in its exercise of authority did so within the limitations. We find that Section 36 subsection 1, C and D had been violated, and we subsequently submit that the court declare Section 4 of the School's Code of Conduct unconstitutional. Additionally, immediate suspension of the learners contradicts the South African School Act of 1996, subsection 1, C, and B and C that state that the school governing body may expel a learner only after a fair hearing and for a period not more than a week. Thus, the counsel of the applicant assert and submit that the procedure followed by the principal of Njondolo Combined School, Ms. Koza, and the school governing body is illegal and unconstitutional as it has failed to follow legal protocols instead. The lack, honorable justices, the lack of discipline and poor academic performances cannot be solved by violating my learners' rights. We therefore submit that there are alternative options and measures that can act both as a measure of discipline and to improve poor academic performances than the ones administered by the principal of Njondolo, supported by the SGB members. The court cannot turn a blind eye over the fact that the right to education is a fundamental right that cannot be tempered by any school or any school governing body. Applicants cannot be deprived their right to education. Section 29 of the Constitution clearly states that the right to educate everyone. Yes,
Counsel, you're being.
Sorry to interrupt you once again, but Counsel, in consideration of the right to education that you speak of and regard as so important, don't you think that the aims of Section 4 are in light of the right to education? And didn't the school see some improvement in discipline after Section 4 was implemented?
Chief Justice, the improvements happened before Section 4 of the Schools Code of Conduct was implemented. And Section 4 of the Schools Code of Conduct is harsh. However, you cannot expel learners for the remainder of the academic year. What about the future? What are you reading into the society? May I continue, Chief Justice?
Yes, thank you, Counsel.
Thank you very much. The Honorable Court instead cannot turn a blind eye over the fact that the right to education is a fundamental right that cannot be violated by any school or any school governing body. Applicants are deprived their right to education. May I hand over to my co-counsel so that she can argue the second leg of our argument? Thank you.
Yes, you may, Counsel.
Adding to what my co-counsel has said, research by William and Clavish Law Corporation has shown that students who have been expelled have a higher risk of engaging in criminal and antisocial behavior or even consume drugs. Suspension increases the student's chance of getting arrested within the same month. On the same wavelength, we humbly refer the court to the case of MEC of Education, KwaZulu-Natal and others versus Pillay 2008, subsection 1 SA 474 CC, paragraph 98. It states that both discipline and education are legitimate goals. However, care must be taken not to state the school's interest broadly. Therefore, we submit that Section 4 of Njondolo Combined School is stated broadly. It is intended to deviate and worship authority over the Constitution itself. Additionally, we submit respectfully that Section 4 of the Schools Code of Conduct contains contradictions and lacks clarity on the basis that the principles in Section 4 tend to be lost in translation and interpretation. We thus submit that any provision of law or code of conduct should not in case be contradictory. The first part of the provision of Section 4 prohibits the use of cell phones, whether on or off, which again is argued that the applicant's cell phones were switched off and in their school bags. The second part states the possession of cell phones within the school premises, that which will result in suspension and confiscation. It is on this contentions that the discussed provisions cannot pass the constitutional test on the basis of the discussed contradictions and ambiguities. With regards to the peaceful assembly aspect, the court is directed to the case of South African National Defence Union versus Minister of Defence and others. As stated in the article by Chamberlain and Simon, the court captured the value of right to protest as a benefactor of democracy and a protection of the moral agency in the society. In terms of legal registration, regulations and rights to protest is firmly entrenched with the South African democratic privilege. The Council therefore contends that the applicants exercise their legal rights to gathering as a gesture to voice their concern. Additionally, the right to protest is a justifiable right, and Regulation of Gathering Act 205 of 1993 Gathering Act was passed in order to give those who feel oppressed the mechanism to voice their concern, that which is further echoed in Section 17 of the Constitution.
Council, while I can appreciate your arguments on the importance on the right to protest, isn't there a way that the protest should happen so there wasn't any notice that was given according to the Regulations of Gatherings Act?
Justice, the right to protest is a justifiable right, my justice, and the applicants had a peaceful assembly, and the gathering was just to voice their concern on the unfairness of the respondents. Should I continue?
Thank you, Council. Please proceed.
In conclusion, Council for the applicants has shown that Section 4 Code of Conduct of Njondolo Combined School is unconstitutional and violates the applicant's right to privacy, their right to peaceful assembly, and their fundamental rights to basic education. Council for the applicants respectfully request the Honorable Court to make an order in the following. Section 4 of Njondolo. Yes, Justice.
Before you pray for relief, just a question regarding the right to protest. Earlier on, both you and your fellow co-counsel made submissions about the importance of the right to education, etc. So don't you think that the protest that the students held violated the right to education of the other students? It's my understanding that there were students who didn't have access to the school while the protest was happening, and there was just a sort of disruption that happened while the protest was happening. So what's your response or submission in that regard?
Not violate any of the other learners' rights, and the gathering was peaceful. So when a gathering is peaceful, it does not violate any of the other learners' rights, and it does not disturb the smooth running of the school.
Council?
Yes, Justice.
The fact states that there were bins that are dragged to block the school entrance, and at some point during the protest, the later protest, there was a fire and a fire brigade was called. Does that still mean that the protest was peaceful?
My Justice, the protest was peaceful, and there was no sign of the culprit who burned the dustbin. So it is not proven that the applicants are the one who burned the dustbin. It was just a peaceful gathering, and no one was identified for burning the dustbin. So it does not mean that the applicants burned the dustbin. May I continue?
Yes.
Immediate return of cell phones to their respective learners immediate lifting of suspension of applicants and release of detained applicants, cost of lawsuits, further and alternative relief, respectfully submitted, counsel for the applicants. Thank you.
Thank you, counsel, for the applicant for your submissions. I will now proceed to the counsel for the respondent. Can the first counsel on behalf of the respondent please approach the bench and make their submissions?
As it pleases the court. Honorable Justice, my name is Nobuhle Tiko, and I'm here on my co-counsel on my left-hand side is Soko Chishani, who will be representing the respondent. We humbly approach the court today to raise 3 issues. Making a decision taken by the High Court to suspend 6 learners' violations to the school's code of conduct, and dismissing the applicant's application. We will use the Constitution, Applicant Schools Act, Government Act, case laws, and fact to prove that the decision taken by the school was not unconstitutional. The respondent, which is the governing body of Njolo Combined School, maintain a decision to suspend the applicant, which are the 6 learners from school, as the best interest of the school, since the applicant do not follow the school's code of conduct. We submit that Section 4 of the school's code of conduct is not unconstitutional. The case of MEC of KwaZulu-Natal and others versus Pile 2008, a paragraph 100 further emphasizes this by stating that rules are important to education. Not only do they promote an important sense of discipline in learners, but they prepare them for the real world, which contains even more rules than the school year. In addition, according to Section 8 of Section 1 of the South African Schools Act 84 of 1996, a school governing body must adopt a code of conduct for learners, and each learner attending the school must comply with the school's code of conduct. Section 8 of Section 4 of the South African Schools Act 84 of 1996 states that nothing contained in this act exempts a learner from the obligation to comply with the rules of the schools attended by such learner. This act clearly shows that learners have to comply with the rules of the school. This act is also there to maintain law and order in schools. The 6 learners did not comply, and the school had no choice but to suspend them. The fact that these learners were told beforehand that the use of cell phone, whether on or off in the school premises by learners, shall at all times be prohibited, and should they be found in possession of a cell phone, shall have that phone confiscated and may be suspended. Cell phones are
Counsel,
Justice.
I appreciate your submissions on the importance of rules, but the applicants have argued that these rules violate certain rights in the Constitution. So wouldn't you then say that sort of the Constitution has more power than that code of conduct, and that the code of conduct must align with the Constitution?
Counsel, there are certain limitations in the constitutional rights. So the school doesn't entirely violate the constitutional rights, because there are the rights that are limited, and there are certain rights that we have limited, that the applicants need to be limited. The applicants' rights that need to be limited.
And counsel, what is that section that provides that rights may be limited?
Section 36, subsection 1, which states that the rights in the Bill of Rights may be limited only in terms in law general application, to understand that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and dignity, equality, and freedom, taking into account all the relevant factors, including subsection A, nature of the right, subsection B, the purpose of the limitation, subsection E, the less restrictive means to achieve the purpose.
And if I may ask you another question, counsel, what about the applicant made the submission that Section 9 of the Schools Act states that a suspension period may not last more than a week. So in this case, we can see from the facts that some of the students, including Sfiso Cele, were suspended for periods extending to a year. Don't you think that it is unreasonable to suspend students for such a long period of time? And also, would it not be in contravention with the period that is determined by the Schools Act?
Thank you, Justice. In response of your question, we can know very well that violating Section 17 of the Constitution, which allows learners to be imprisoned for 1 year
the school was reasonable and considerate to the learners to give them a 1 year suspension from school instead of giving them imprisonment for 1 year. So the school was very considerate and not harsh on the punishment. Justice?
You can.
Thank you. Cell phones are not important in schools, and they can be very disruptive. Section 14 can be limited because it is justifiable and reasonable. And we hear our applicants saying that the learners' cell phones were off and inside their school bag and it doesn't affect the school, whereas 3 cell phones were turned on and they were warned the day before that a search will be conducted. So no cell phone must be bought at school. This case shows that the learners are not prepared to follow the rules. Even Section 29 of Section 1A is limited because if children are involved in misconduct, then the school has to take duties or serious measures must be taken and they have to be suspended. That limits their right to education. To continue on my arguments, I will say that the principal did try an alternative by calling an urgent meeting to parents, saying that if mistakes are made, this must be discussed and a way forward must be found. The learners blocked the entrance of the school and the meeting could not take place. This clearly shows that learners were disorderly, unruly, and were not prepared the rules of the school, whereas they are the ones who agreed to have a better disciplinary measures. If we can go to our case, in page 1, paragraph 3, it states that learners agreed with educators that there has to be greater disciplinary measures, whereas now they are failing to comply with the disciplinary measures that have been implemented. Children are not born with discipline. Therefore, the school has a duty of inculcating discipline in learners. Failure to do so results in poor performance, like it was happening before Ms. Koza was appointed as the principal. Honorable Justice, I would kindly like to hand over to my co-counsel to continue with the argument. Thank you.
Good morning, Honorable Justice. In addition to what my co-counsel said, Section 8, subsection 2 of the South African Schools Act, number 84 of 1996 states that a code of conduct must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. In this case, suspending the 6 learners will ensure the quality of the learning process since the applicants failed to comply with the school's code of conduct. We also argue that the SGB's decision is not unconstitutional and it does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. Section 36, subsection 1 of the Constitution states that the rights in the Bill of Rights may be limited only in terms of law general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all the relevant factors, including subsection A, the nature of the right, subsection B, the importance of the purpose of the limitation, subsection C, the nature and extent of the limitation, subsection D, the relation between the limitation and its purpose, and also subsection E, less restrictive means to achieve the purpose. The fact that the applicant did not provide the notice of gatherings is in violation of Section 3 of the Gatherings Act, number 205 of 1993, which states that the convener of a gathering shall give notice in writing signed by him of the intended gathering in accordance with the provisions of this section. In the case of Lungwana and others versus S and another in 2019 in the Constitutional Court Lungwana case, paragraph 16 emphasizes the need for providing the notice of gatherings by stating that if the gathering proceeds without a formal notice, then Section 12, subsection 1A provides that it is a criminal offense to convene a gathering without giving the requisite notice as prescribed in this act. It is only the convener who is criminally liable for failure of giving the notice of gatherings under Section 12, subsection 1A. The fact that there was a fire in the Yes, Honorable Justice.
Since we're speaking about children and we're dealing with high school children who most genuinely just had concerns about things that were happening in the school, isn't it a little bit harsh to make them or to make a child criminally liable for something as small as not submitting notice?
Yes, no, it is not. Because the applicants were well informed by the police on the day of the spontaneous gathering. The police informed them that they need to provide the notice of gathering. So, as a responsible citizen, as a responsible civilian, you have to educate yourself about being able to not being an outlaw. It's simply just trying to be an outlaw. That's what I say in response to your question.
Thank you so much, Counsel. You may proceed.
The fact that there was a fire in the administration building and also near the teachers' parking is in violation of Section 17 of the Constitution, which allows peaceful demonstration. Cognizant of the fact that there were no culprits identified on the scene, if I may put it figuratively, since the learners failed to comply with the school's code of conduct, it means that they were simply rebellious and if I put it figuratively, there were the rotten potatoes in the bag and they wanted to convert other children into rebels. They had a huge negative effect. They had a huge negative influence on the rest of the learners because the learners before this protest, they agreed for a need for greater discipline in the school because they knew what they wanted in life. And they were well informed that there's a search will be conducted for search of cell phones in order to not violate Section 4 of the school's code of conduct. May I continue, Honorable Justice?
You may.
Blocking the school entrance and denying other learners access to the school also violated other children's right to a basic education in terms of Section 29, subsection 1A of the school of the code of conduct because the school ended up being closed because of this situation. The applicants also violated Section 12, subsection 1C of the Constitution, which states that everyone has the right to freedom and security of the person, which includes the right to be free from all forms of violence, either from public or private sources. In the case of Setau and another in 2013 in the Constitutional Court, Gavas case, in the case of Setau and another versus Gavas and others in 2013 in the Constitutional Court, Gavas case, paragraph 53 emphasizes peaceful demonstration by stating that nothing said thus far detracts from the requirement that the right in Section 17 must be exercised peacefully. It is only when they have no intention of acting peacefully that they lose their constitutional protection. In conclusion, the respondent maintains its decision to suspend the 6 learners from the school as the best interest of the school since the applicants failed to comply with the school's code of conduct, whereas other learners agreed with educators for a greater need of discipline. We humbly submit that the High Court was correct in finding that there was no violation of the right to privacy and a basic education. The respondent prays to this court to rule in their favor by dismissing this case. I think.
Counsel, sorry, before you leave, one last question. Regarding the statement you made about suspension, do you not think that there were maybe other measures that the school governing body could have taken to achieve the same results without maybe compromising the students' right to education?
In terms of Section 36, subsection 1(1) of the Constitution, rights may be limited, considering the fact that the learners were involved in serious misconduct, which is dealt with by the law by expulsion. So, in consideration of that fact, the school was actually considerate to the learners because of Section 12, subsection 1(a) of the Gatherings Act, number 205 of 1993, states that any person who convenes a gathering in respect of which no notice or no adequate notice was given in accordance with the provisions of Section 3 shall be guilty of an offense and on conviction liable. In the case of a contravention referred to in paragraphs A to J, to a fine or to imprisonment for a period not exceeding 1 year or to both, such a fine and imprisonment. So the learners could have been imprisoned for a year. So the school was actually considered, and the learners were actually suspended. And the school also implemented the use of positive discipline measures in the 1-year suspension by referring the learners to a diversion program. The principal did try other alternatives to try and get the parents and find a way forward regarding this whole situation. And the learners became aware of this meeting and they disrupted its proceeding. This means that the applicants, they did not want any justice through positive channels. They wanted to just break the law in order to get their voice heard, because it is a violation of the law to convene a gathering without a notice, and it is conviction liable.
Thank you so much, Council.
Thank you.
That concludes the submissions for respondent, and applicant may come forward and present their rebuttals. Applicant, you reserved 2 minutes for rebuttal, so you may make your rebuttals.
Thank you, Chief Justice. As the court pleases, the code of conduct is harsh towards my clients and violates their right to privacy, the right to basic education, and the right to peaceful assembly. The code of conduct tends to move my clients away from school. What kind of future leaders does Mjondolo Combined School breed onto the society? Is it not effective to suspend a learner for the remainder of the academic year? Well, it is. I would like to remind the Honorable Court not to turn a blind eye over the fact that the Constitution is the mother umbrella of the South African law, and no one can worship authority over the Constitution itself. As we know that we live in a technologically advanced world, like now we deliberately submit our cases through technical devices. Cell phones should be allowed and admitted in schools for further and alternative academic benefits. I thank you, Chief Justices.
Thank you, Councillor.
Hey, it's a look. 30S 139. Team support.
Can you please, applicant, can you please mute your mic? Thank you. This concludes our session. And if I may ask my fellow justices if they have any points of feedback to offer to the council.
I will go first. Let me just turn my camera on so that this is a bit more personal. But I just wanted to say well done to all the teams for all your hard work and just how well you've prepared for this competition. It's really impressive to see arguments coming from students at your level. I'm actually interested to know how old you guys are, because I think the initiative you're taking on is great, and I really hope that you, I don't know, someday decide to be lawyers or something. But with that said, well done. You were well prepared. I just want to give you feedback for the rounds going forward. The first one is, remember that when a judge asks you questions, to just take your time, be calm, and listen to what they're trying to find out from your submissions. Judges aren't asking questions because they want to be intimidating or because you're saying something wrong. They're asking questions because they want to truly understand what your submissions are, or maybe because they're confused on a point of your submissions. So just keep that in mind. I saw the second speaker of the respondent just take a moment to compose himself before answering the question, and I thought that was a good move to do. I also want to remind you that you are not bound to your scripts and to what you have prepared. So you have prepared well enough for you to understand the law and to understand your cases. So don't try and tackle questions and issues directly with the knowledge that you have, and trust in the knowledge that you have. So if a question needs you to deviate from your script or refer to knowledge that you have that's not written before, or to rely on sort of your own logic, then allow yourself to rely on that. And that way we can trust that you really do know what you're speaking about beyond what you have prepared. But otherwise, I thought you guys were quite persuasive, really impressed and inspiring to see such young people making good arguments. So that's it from my side.
Thank you.
Well, for my side, I agree with everything that my fellow judge has said. And yeah, mostly I appreciate the efforts that you guys took to answer the questions, and good luck with the competition going forward.
Thank you.
Thank you, Justices. I'd also offer feedback. I echo my fellow colleagues' sentiments. Think that both teams were well prepared, and in respect of questions, of course, more improvement can be done going into the next rounds. And I think that your submissions were confident, and I wish you good luck going forward. And I think
You have muted yourself.
oh, sorry. I apologize for that. The session has ended, so you are free to leave the call.
Thank you.
Thank you, Chief Justice.
Justice. First speaker is Mabele Nsmcc. And second speaker is Nonkuselo Sitong.
Please write them down in the chat so we can have the proper spellings.
Applicants, can you hear me? Applicants, can you hear me? Can the applicants hear me?
If it pleases the court, justices, we are still having an audio issue, justices, but our coaches said that they are working on it.
So you can't hear us at all.
Yes, the justices, we can't hear you properly.
But you are responding to me, so that sort of imply that you can hear me. You know, you understand what I'm saying, isn't it?
The volume is low, you just, and it's not clear.
Can the other justices confirm if they can hear me properly, so that we are sure that it's the applicant?
We can hear you loud and clear. I can hear everyone loud and clear.
So we're just going to wait for 2 more minutes. Hopefully the applicant can fix their technical issue. Otherwise, because we also have to be conscious of time, if it takes the applicant longer to fix that issue, maybe we might have to start with the respondent, because we have to finish this session, and there have to be like another session after this. So we are really running out of time.
We sorted your justice.
Okay, thank you very much then. Please, you can proceed and address the court.
If you please the court, your justice, my name is Nsmcc, and along with me is my co-counsel, Nonkuselo Sitonga, and we will be appearing on behalf of the applicant. I shall take 9 minutes of this court's time. My co-counsel shall take 9 minutes of this court's time, and we will reserve 2 minutes for rebuttal. Your Justice, I shall be taking the first issue and addressing the court about the unjustifiable limitation based on the rights to privacy and education in terms of section 14 and 29 respectively. If it pleases the court, Your Justice, I would like to move on with my issue 1. Firstly, we put forward the importance of the right to privacy. Your Justice, this right promotes the protection of human dignity, the sense of security and confidence in a way that boosts one's self-esteem. The Constitution realizes the importance of privacy as is stipulated. Section 14 of the Constitution, which states that everyone has a right to privacy. This includes the right not to have their person or their home searched, the right not to have their property searched, the right not to have their possession seized, and the right not to have the privacy of their communications infringed. We therefore submit to the court that the respondents in this matter did not acknowledge the applicant's right to privacy, as they inflicted a code of conduct or a law that incited the searching of learners' bags and the confiscation of their cell phones. We therefore say that this was done without a justifiable reason or reasonable suspicion. If it pleases the court, Your Justice.
Counsel, before you move on, so you said the code of conduct was not justifiable, but we were made to understand that the pass rate of this institution has been very low because of the distractions that happen to students, because they are always on their cell phones and other devices. How do you now tell this court that it is not justifiable to put in place a code of conduct that prevents students from being distracted?
Firstly, Your Justice, we submit to the court that there was improvement before the implementation of Section 4 of the School Code of Conduct, and that our argument is based on the manner in which the Code of Conduct was operated or conducted, Your Justice, in a way that it violates the applicant's rights to privacy, Your Justice. If you please the court, we would like to continue, like to proceed. We therefore say that it is unjustifiable because in terms of section 8A subsection 2 of the South African Schools Act, which states that the principal or his or her delegation may at random search any group of learners or the property of group of learners for any dangerous object or illegal drug if a fair and reasonable suspicion has been established. Now, Your Justice, in terms of the South African Schools Act, a dangerous weapon can be defined as a material or device, any firearm, gas weapon, any object or instrument that may be employed to cause bodily harm to a person or damage the property or render the person temporarily paralyzed or unconscious. We therefore say that the cell phones do not fit the description of a dangerous object, and therefore any search conducted as a result of reasonable suspicion of suspicion is not constitutional. If it pleases the court, would like to proceed. Justice, it was also stated under Article 16 of the Convention of the Rights of the Children that no child shall be subjected to arbitrary or unlawful interference with his or her privacy, and that a child has a right to be protected from, has a right to protection of the law against such interferences or attacks, meaning the act committed by the school was unconstitutional, Your Justice. If you please the court, I would like to move on with my second matter in this issue. We submit the limitation placed upon section 29, which is the right to education. It is stated that everyone has a right to education, including adult basic education. And we therefore submit that the limitation placed upon this right was unconstitutional due to the existence of less restrictive means to achieve the same purpose. We therefore put forward section 36, subsection E.
Counsel, can you explain to this court some of the less restrictive means that the respondent could have adopted in this instance?
Your Justice, if the school wished to say maybe punish the learners for their indiscretions or for misconduct in a less restrictive way, they could have, Your Justice, requested a meeting with their parents or give the learners extra homework or give them detention where they will be taught about responsibilities, Your Justice. And this way they will be in this way, they will be keeping order in a way that does not violate the applicant's right to justice.
Well, Counsel, the meeting with the parents and the homework, it appears to me that they will not solve the problem that we have here. The problem here is that the students are distracted when they are in school. So even if they ask for a meeting with the parents, if they give them extra homework, it's not the same. The concern of the school here is the activities of the student when they are in school.
Your Justice, the meeting that would be requested will be to discuss the learner's misbehavior, Your Justice, in maybe carrying the cell phones to school. And thus, if a phone is confiscated, we believe that it is enough punishment, Your Justice. So limiting the right to education is not justifiable, Your Justice. It's not of last resort. It's of it's of instant, Your Justice. It was not of last resort. If you please the court.
You can continue.
Your Justice, it was stated under the 6th edition in support of this, Your Justice. It was stated under the 6th edition of the Bill of Rights Handbook by John DeVal and Ian Curry, when it was stated that if a limitation will not be proportionate if less restrictive means could be employed, Your Justice, and that if less restrictive methods exist, then the less restrictive methods must be preferred. And now, Your Justice, the respondents or the school in this matter did not seek other alternatives or less restrictive alternative ways to achieve the same purpose. Rather, they decided to limit the right to education without seeking less restrictive ways, Your Justice, and thereby not limiting but violating this right to education by denying them the chance to education, Your Justice. If it please the court, I would like to hand over to my co-counsel to unpack the second issue, which is about the unjustifiable decision taken by the SGB. Please, the court would like to take my leave.
Before the second oral list begins, please pay attention to the screen. I'm going to be putting up this paper when you have 3 minutes left, and then again when you have 30 seconds left. Thank you.
If the court pleases, the justices, my name is Tonga Nanguselo, and I will be unpacking the second issue concerning the constitutionality of the unconstitutionality of the SGP's decision to suspend their learners and in that matter violating their rights to peacefully assemble in terms of Section 17 of the country's constitution. Your justices, firstly, we submit the ICCPR, which states that the right to peacefully assemble shall be recognized. No restrictions may be placed upon the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security, of public safety, public order, the protection of public health, the morals and the protection of the rights and the freedom of others. Your justices, we submit that the school refused to obey the international law by suspending the applicants when they were merely exercising their rights to peacefully gather. Your justices, there were 3 gatherings which led to the suspension of these learners. Your justices, the first gathering took place spontaneously as it was a result of the respondents' immediate decision to suspend the learners. So there was no need to provide notice, as is stated in Section 12, subsection 2 of the RGA, that it shall be in defense to the charge of the convening that a gathering in contravention with Section 12, subsection 1A, that the gathering took place spontaneously. And therefore, your justices, the first gathering took place spontaneously, and so therefore there was no need to provide a notice. Your justices, furthermore, we submit that Your justices, furthermore, we submit that in the Mlungwana case, paragraph 94 declares section 12, subsection 1A of the Regulations Gathering Act unconstitutional. Your justices, it is stated that Section 12, subsection 1A is more immediate purpose incentivizing the giving of a notice through the threat of a punishment. There is no doubt that criminalizing the failure to give a notice incentivizes the giving of a notice to some extent, but criminalizing is not necessary to incentivize the giving of a notice. It is to this latter factor that I now turn, and it was confirmed by the Constitutional Court that the absence of a notice does not give a rise to violence. Your justices, we submit that the respondents may argue that there was no notice given in the second and the third gathering, but your justices, not providing a notice does not mean that there will be violence or anything. And also, your justices, it is a bit too much to actually suspend the learners for not providing a notice for a gathering, your justices, as there was no violence.
Counsel, you say that it's a bit too much to suspend the learners just because they didn't give notice. Do you suggest an alternative measure that could have been taken against the learners?
As a matter of fact, your justices, yes. Your justices, the learners could have not been suspended, your justices. They could have been sent to detention or have their parents called so that the parents and both the teachers can decide on which way to suspend the learners. And that also will be working with Section 28 of the Constitution, which is a child's best interest is of paramount importance in a matter concerning the child. So your justices, if the school had coordinated with the parents, to actually provide better punishment for the learners. And also, your justices, the school could have also provided a warning for the learners. Proceeding, your justices, we submit that the banning of the fresh beans in the first violence was not necessarily peaceful, but your justices, it was means of retaliation against the respondents' unjustifiable limitation on the right to education of the learners. To support this, Your Justices, we submit the international law, which is the United Human Rights Office report, which states that the use of violence during protests is neither a new nor an exclusive feature of Venezuelans. Social psychologists from different countries have demonstrated that emotions, the perceived efficacy of violence, or the lack of collective efficacy could be understandings for people to consider getting involved in violent actions during protests. Your Justices, we submit that the school lacked of collective efficacy when they suspended the learners. Hence, the learners had to resort and retaliate to means of trying to get the school's attention because the learners were suspended with no disciplinary and no warning. So, Your Justices, the learners had to do something to actually obtain the attention of the respondents. Furthermore, Your Justices, we submit that the applicants cannot be held accountable for violence that was not caused by them, as it is stated in the European Convention of Human Rights, Article 11, Section 8, which states that, nevertheless, an individual does not cease to enjoy the right to peacefully assemble as a result of sporadic violence or other punishable act committed by others in the course of the demonstration if the individual in question remains peaceful within his or her own intentions. Your Justices, we submit that yes, there were fires and other punishable acts, but Your Justices, there were no culprits found, and therefore, Your Justices, there is no way to actually state that it was the applicants who actually caused these fires, and therefore, Your Justices, they cannot actually be held accountable to an extent of even being suspended as for sporadic violence, Your Justices.
Counsel, you say that the school could have met with the parents and discussed on a measure that can be taken against the students. But according to the facts, there was a meeting set with the parents at around 6 p.m. and the students then protested, which prevented the meeting from going forward. So do you now still believe that the school could have taken any measures if the learners themselves did disrupt the meeting?
If it pleases the Court, Your Justices, can you please clarify the question?
Okay. You say that the school could have met with parents, right, to come up with an alternative measure to take against the students instead of a suspension. But according to the facts, we can see that after a meeting was set for 6 p.m., the learners sent WhatsApp messages organizing a protest that disrupted the meeting from going forward. So, since a meeting was indeed set with the parents, do you now still believe that the school had another measure that they could have taken if the students themselves stopped the meeting from going forward?
Your Justices, we submit that since the meeting could not go forward, Your Justices, the same way that the respondent sent a message informing the parents of that there should be a meeting to discuss a way forward, the school could have sent a message, Your Justices, stating of what should be done to those learners instead of requesting a meeting whereby they will all meet, because, Your Justices, even the learners were still angry about the decision of being stripped of their rights to basic education. Proceeding on to Your Justices, we submit paragraph 61 of the Statute versus Gava State, which states the right to peacefully assemble is central to our constitutional democracy. It exists primarily to give a voice to the powerless. Your Justices, the applicants were powerless in this situation and were forced with a school system that infringes upon their rights. Your Justices, first of all, the school started with a code of conduct that authorized their possessions being searched and seized, and therefore, even in the code of conduct, it is stipulated that they will be suspended. Your Justices, the school could have used less restrictive means to punish learners who are actually disobeying the law. So, Your Justices, the learners could only assemble to get their voices heard by the school. Your Justices, in summation of our argument, the applicants have shown that the SGP's decision to suspend the learners was unconstitutional as it violates their right to peacefully assemble. And Your Justices, concerning the school's code of conduct, in our constitution, it is stated in section 2 of the country's constitution, in section 2 of the South African Republic Constitution 1996, it is stated that this constitution is the supreme law of the Republic. Any law or conduct inconsistent with it is invalid and other obligation imposed with it must be fulfilled. Your Justices, this simply means that the constitution is the supreme law of the land, and therefore, Your Justices, since the school's code of conduct was invalid, and since the code of conduct was breaking many of the rules in the constitution, it has to be declared invalid. Your Justices,
Council, I just need one clarification. So you spoke about the violation of the right to peaceful assembly, but how exactly did the respondent violate the right to peaceful assembly here? Because it's the police that arrested them and the fire brigade and all of that. What role did the school play in all of this that amounts to violation?
If it pleases the Court of Justices, may your Justices please clarify the question a bit more?
I'm saying, what role did the school play in violating the right to peaceful assembly of the students? How exactly did they violate the right to peaceful assembly?
Your Justices, the respondents violated the right to peace. Your Justices, the respondents violated. If it pleases the Court of Justices, may I be given a minute to answer the question, Your Justices?
Yes, please.
Go ahead.
Thank you, Your Justices. Your Justices, the school violated the applicant's right to peaceful. Your Justices, in the first protest, the learners were told by the school that they should stop because it was illegal, and they said that it was spontaneous, and so therefore that was the last time they had a meeting with the police. And then, Your Justices, the school violated their right to peacefully assemble, Your Justices, by not wanting them to voice out their concerns, Your Justices, because they said that they were being destructive and violent, Your Justices, when it was a result of sporadic violence. So, Your Justices, by suspending them for practicing their right to peacefully assemble, that is itself violating their right. If it pleases the Court of Justices, if we therefore pray for this court to grant the following orders.
Applicant, your time is up. The respondents can start with their submissions. Thank you.
Thank you, Justices.
Greetings to you, Your Justices. May it please the Court. My name is Nsmcc and my co-counsel's name is Nsmcc. We both counsel for the respondents. I'll be spending approximately 10 minutes addressing the constitutional validity of Section 4 of the School's Code of Conduct, and my co-counsel will therefore address the SGB's decision, which is not unconstitutional and does not violate the learner's right to peaceful assembly in terms of Section 17 of the Constitution. If I may submit the facts of the case, Your Justices. Your Justices, my clients here, the SGB, implemented a code of conduct after a consultative process with the parents and the learners in line with the South African Schools Act. The respondents and the applicants agreed in the code of conduct that if they were to find a learner in possession of a cell phone, it would be confiscated. This was done by the SGB after they saw that there was a high level of ill discipline and low pass rate at the school, informed by learners who are constantly using their phones during school time. The school's pass rate improved drastically after the adoption of the code of conduct. One of the learners was found with a cell phone during school hours and it was confiscated. We submit as follows. In terms of Section 2 of the Constitution is the supreme law of the country. Any law or conduct that is in conflict with the Constitution, it is invalid. Most importantly, the rights that the applicants claim to have been violated by the respondents have responsibilities. As such as the learners has the right to education, the responsibility or duty is to respect the rules, authorities, and regulations put in place. We accept that every child has the right to education in terms of Section 29 of the Constitution. However, this right can be limited in cases where the learner is refusing to respect the school's code of conduct or any other laws. The 6 learners had to be suspended because they were infringing the other learners' right to education, as they made it hard, if not impossible, for them to gain access to the school's gates. My clients here were acting in the best interest of the majority of the learners as well as the interest of the educators. As such, the suspension was necessary to preserve peace and stability at the school. The disruption had been going on for a few days at the school and has had a serious implication on teaching, the learners, and the property. The school admin block was on fire due to the incitement of the applicants to the other learners. As such, the SGB had to take action in an attempt to preserve the property of the school. The code of conduct was developed and approved by the SGB, meaning even the applicants accepted the obligations imposed by the code of conduct. At no stage did they challenge the constitutional validity of the code of conduct. The applicants decided to associate themselves with a school that prohibited the use of cell phones during school hours. The applicants cannot therefore want to argue that the school's code of conduct is unconstitutional, as they have been found to have violated it. The applicants note that the introduction of the code of conduct has improved the school's pass rate and the ill discipline as previously encountered by the school on previous occasions. Section 28, subsection 2 of the Constitution states that when dealing with the rights of the child are of paramount importance. We accept that position. However, such a right is subjected to the law of general application. The SGB also have the obligation to look after the interests of the other learners who are respecting the code of conduct or any other laws. Section 8, subsection 4, Schools Act number 84 of 1996 states that nothing in this act exempts a learner from the obligation to comply with the code of conduct, meaning each and every learner has the obligation to comply with the code of conduct. The applicants just want special attention by not respecting the school's code of conduct, which was adopted by them. The right to privacy in terms of section 14 of the Constitution of the applicant has not been violated, rather limited. As such,
I'm just wondering, with respect to the right to education of the applicant, can you hear me? Looks like you're struggling to hear me. Okay, so with respect to the right to education of the applicant, when you suspended them for bringing cell phone to the school, does that not technically defeat the whole idea of trying to ensure that they do well in school?
Well, the justices, them in the first place, by not adhering to the school's code of conduct, made it clear that they don't want to be educated.
Really? But they come to school. If they don't want to be educated, I don't think they would come to school. They come to school. The only problem here is they brought their cell phones, which is contrary to the code of conduct. But couldn't you have used a less restrictive means, like the applicants were arguing, to preclude them from doing these things, apart from the suspension?
We could have used less restrictions, but then for them to cause chaos at the school, it made it clear that they don't want to be at school. And
Council, let's take it one after the other. Remember, in the fact, it was after you suspended them that led to the whole chaos. So my question now is, before the chaos, don't you think that code of conduct that you could have used a less restrictive means instead of saying you will suspend the student? Couldn't you have used a much more less restrictive means that would not have resulted in the chaos that happened eventually?
We could have used less restrictive means. Your justices.
Okay, Council, please continue.
Section 8, subsection 4, Schools Act number 84 of 1996 states that nothing in this act exempts a learner from the obligation to comply with the code of conduct, meaning each and every child has the obligation to comply with their code of conduct. The applicants just want special attention by not respecting the code of conduct which was adopted by them. The right to privacy in terms of section 14 of the Constitution of the applicants has not been violated, rather limited. As such, a limitation was reasonable and justifiable. The SGB did not just wake up and decide to conduct a raid at the school. Their action was informed by a series of non-compliance of section 4 of the school's code of conduct. Upon conducting a raid, they managed to find a few cell phones. This then justifies the action of the respondents. The police conduct to go through the WhatsApp of the applicants was informed by the fact that the applicants organized an illegal march, incited other learners to join, and later on the school's admin block is on fire. Any law enforcement agency will obviously want to investigate, and the investigation has proved that the suspects organized an unlawful march. This then justifies their limitation to their rights of privacy. Furthermore, the applicants have always known that anyone who is in violation of section 4, their cell phone will be confiscated. This is nothing new. The applicants have always known that. If there are no more questions, I'd like my co-counsel to proceed.
Greetings to you, your justices. May it please the court. My name is Nsmcc, and I am counsel for the SGB of Njondolo Combined School, as my co-counsel has already mentioned. If I may submit my case, your justices. The protest by the applicant was illegal as it did not comply with Section 3, subsection 1 of the Gatherings Act, number 205 of 1993. The latter act prescribed that notice be given before a protest can be declared as lawful and in line with Section 70 of the Constitution. The applicant did not issue any notice, despite the fact that they had already planned for the demonstration. This is evident from the fact that they made posters a day before the demonstration. The convener did not appoint marshals, ensuring that the protest was peaceful in terms of Section 8, subsection 1 of the Gatherings Act. Therefore, the police and the school are well within their right to arrest and discipline anyone who contravened with the law. The applicant argument that they were demonstrating their right to peaceful demonstration in terms of Section 17 of the Constitution is false and illegal on its nature. As such, the limitation imposed by the police and the SGB is reasonable. In conclusion to my argument, I would like to state that the respondents appreciate the rights of the applicant as contained in the Bill of Rights, which is in Chapter 2 of the Constitution of the Republic of South Africa. The respondents does not deny the fact that the applicant are entitled to such rights. However, the respondents contend that such rights cannot be applied in isolation, meaning that they are subjected to the law of general application in terms of Section 36 of the Constitution of the Republic of South Africa. We therefore submit that all the facts which we have presented support the fact that the limitation of the applicant's rights is reasonable and justifiable in an open democratic society. A balance between the rights of the applicant and the rights of the others, particularly the majority, must be observed to ensure that the limitation is reasonable and justifiable. The applicant have failed with distinction to establish a prima facie case. The applicant's case is weak and weak in substance in law. In light of the above, with reference to relevant authority, we humbly request the following prayers.
Counsel, just before you tell the court your prayer, so I'm just wondering, don't you think from what we have before this court, the fact that the other students, apart from the students that were suspended, the fact that they joined in this protest, if you like, does it not tell you that the code of conduct is not a fair one?
Justice. The code of conduct is fair. The reason for the suspension was because they did not follow Section 4 of the school's code of conduct, meaning that the protest has nothing to do with the suspension, but rather with the violation of Section 4 of the school's code of conduct. Justice.
I'm just wondering, you said it has nothing to do with their suspension, but the violation of the code of conduct. But they were suspended on the basis of violating the code of conduct. So it looks to me as if the two are the same.
Injustice. My response was that the suspension was because they brought the phones to school, which was not in line with Section 4 of the School's Code of Conduct. But I would state that we appreciate the rights and to education, but the protest, they are the ones who started the protest, meaning that they are the ones held liable for every misconduct of the protest.
Thank you, Council. You can proceed.
In light with reference to relevant authority, we humbly request the following prayers: that the case of the applicant be dismissed, that the suspension of the learners be upheld as ruled by the High Court, that the applicant pay the order of cost. If there are no more questions, Your Justices, I would like to descend the podium.
Okay, I would like to call on the applicants to give their rebuttal for 2 minutes.
If it pleases the Court of Justices, first of all, the Council for the Hourly and Friend have stated that the Code of Conduct was constitutional. Your Justices, firstly, we submit that the Code of Conduct was unconstitutional because even in its implementation, it is in contradiction with Section 14, subsection C, which is the right not to have your possession seized. Your Justices, it is clearly stated in the Code of Conduct that a cell phone can be confiscated, and that alone is a violation of Section 14, subsection C. And secondly, Your Justices, we state that the suspension was an unjustifiable limitation according to Section 36E of the Constitution, Your Justices, which states the less restrictive means to achieve the same purpose. Your Justices, the respondent could have used less restrictive means to achieve the same purpose. Let's not forget that these are minors, and Your Justices, according to Section 28 of the country's Constitution, a child's best interest is of paramount importance in a decision made for the child. So the school could have not suspended these learners, but maybe provided detention for them. Your Justices, to rebut on the second issue, Your Justices, the Council for the respondent state that it was illegal because it had no notice. Your Justices, firstly, we submit that it was a demonstration. So, Your Justices, there is no need to provide a demonstration, and Your Justices, there was no way that the conveners could have anticipated that more people will join in on the protest. Secondly, Your Justices, there was unpeacefulness. Your Justices, unpeacefulness was a result of sporadic violence, as it is stated, Your Justices. As it is stated in the Garvey's case, as it is stated in the Garvey's case, in reference to the European Court of Human Rights, that an individual does not cease to enjoy the right to peacefully assemble as a result of sporadic violence or other punishable acts committed by others in the course of the demonstration, if the individual remains peaceful in his or her own intentions. Your Justices would therefore submit that the case of the respondent was incorrect because the Code of Conduct itself was in contradiction with the Constitution, and it is stated in Section 2 of this country's Constitution, which states that, which is the supremacy of the Constitution. It is stated that this Constitution is the supreme law of the Republic. A law or conduct inconsistent with it is invalid, and the obligation imposed. If it pleases the Court of Justices, may I be given 30 seconds to finish up?
Okay, finish up.
Your Justices, as I was stating, the supremacy of the Constitution, it is stated that the Constitution is the supreme law of the Republic. A law or conduct inconsistent with it is invalid, and the obligation imposed by it must be fulfilled. We therefore, Your Justices, submit that the Code of Conduct is invalid because it does not violate one, but violates two of the laws which are in the Republic of South Africa. And those laws are Section 14 and Section 29 of the country. Its implementation was unconstitutional, Your Justices. Thank you.
Thank you, applicants and the respondents. I would like to ask my fellow judges if they have any feedback to give to the both teams.
I would like to just thank both teams for the effort that they put in. It did reflect in the arguments that you made. You were both quite persuasive. So thank you for the hard work you put in and well done. And all of the best going forward.
I would also join Justice Lulama to say that well done to you guys. It's not really easy coming to make this argument before 3 justices. And I also like how you guys handle the questions. I mean, I know the questions were probably a bit tricky here and there, but you coordinated yourself well. Just by way of advice, hopefully you progress to the next round. I think for some of the speakers, you were a bit too fast. I think this is particularly the second speaker for the applicant. You should try to pace yourself when you talk. And also, I would just say, even though this is a virtual round and we are all on Zoom, remember you are appearing before the Constitutional Court and there is the need for decorum. So you should also watch, because we can see you on the screen and we can see when you move your papers around and when you try to get things, at times it looks like you are making eye contact with someone else in the room. I mean, I understand the fact that it is a virtual session, but you should also try as much as possible to act like you would act in a real court. But otherwise, good luck, good job, and I will hand over to the presiding judge.
Thank you. And just to echo on what my fellow judges said, we appreciate the preparation you made for today and the efforts that you took to answer the questions. Also, as pointer, just try to slow down when you answer the questions so we can hear whatever you're saying and follow properly. And for the second respondent, please try not to move so often because it's a bit distracting for you to be moving back and forth while you're doing your submissions. But overall, thank you and good luck going forward in the competition. And the court will adjourn. You can leave the meeting. Thank you.
Hi, everyone. My name is Trisha. I'm a senior associate with Cliff Decker Hofmeyer. I will be presiding today. I just want to welcome everyone. Apologies for the late start, but I'm glad that everyone is here today. I'm terribly sorry to hear about the speaker for the second team that unfortunately has fallen ill. We hope that he or she will feel much better soon. I think mostly we understand the layout of today's proceedings. I think Simon has made it quite clear to everyone. If there are any questions, please feel free to ask them. I'm going to ask each of my fellow judges just to quickly introduce themselves. And then I think once we've done that, we can start with the applicant. May I ask that each of the applicant speakers just get up and introduce themselves as well. We've already got your names in the comment section, but if you could please just introduce yourself just for my fellow judges, just so that they can meet you as well. Thank you very much. I think if each of my colleagues can go ahead, please, and just maybe if you're happy to switch on your camera. Thank you.
Okay, I'm Precious Motlokwane and I'm a final year LLB student at the University of Pretoria, and I'm going to be one of the judges.
Tricia, I see Rahula exited again. I'm trying to get hold of her again once more. I'm not sure what the issue is.
Not a problem, Simon.
The root of it, if she's unable to join by reason of technical issues, I can just find a replacement just quite quickly. So let me just...
Okay. Sure, not a problem. Well, team, sorry for the delay. I think we are trying to find our third judge, which we will hopefully find soon. Since we've got everyone's names now, I think you guys can sort of just start readying yourself, get your notes ready, and we will hopefully start very soon. I do apologize for the delay. Let me just turn back on my video. Good day, everyone. For those who have just joined us, my name is Trisha. I am a senior associate with Cliff Decker Hofmeyer attorneys. I will be presiding today. Can I please just ask, sorry, I know my one colleague, she has already introduced herself, but our third adjudicator has just joined us. I'm sorry, so can I ask if you wouldn't mind, please, doing a reintroduction? If I may ask my colleagues just to briefly switch on their screens if they feel comfortable with that, just to do a brief introduction, and then we will start with the oral rounds. If I can ask each of the applicant teams and then of course the one respondent. Please also just to introduce yourself briefly before you start with your oral submissions. Thank you.
Hi, Justice. I am Justice Bilankulu. Unfortunately, I can't switch on my camera because my Wi-Fi is really bad and I won't be able to hear it all.
Not a problem. Thank you for being with us today.
And I'm Precious Mutlokwani. I'm a final year LB student and I'll be one of the judges for today.
Thank you very much. Can I please ask the applicant team if they can proceed? Like I said, I'm sure you're all familiar with the rules. If you do need any clarity, you can please let us know. But if I can ask the applicant team to please switch on their camera, if we can commence with the introductions and then with the first speaker. Thank you.
I am Mr. Beja, and with me is Mr. Lau, and we are the counsels of the applicants.
Thank you very much. You're welcome, and you can go ahead.
I will be addressing the first matter of Section 4 of the Schools Code of Conduct that is unconstitutional and that violated the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. And my counsel will be on the second matter of the SGB's decision that is unconstitutional and that has violated the learner's right to peaceful assembly in terms of Section 17 of the Constitution of South Africa. We will be leaving 3 minutes for rebuttal, if the court pleases.
Yes, you can proceed. Thank you.
The question before the court today is whether the applicant's right has been violated by the respondent's application of Section 4 of the Schools Code of Conduct, which imposes a suspension of the applicants, and whether the SGB decision to prevent the learners from protesting and ultimately suspending them was constitutional in terms of Section 17 of the Constitution of South Africa. As counsels of the applicants, we argue and submit that the case of Mjondolo Combined School and the SGB, the respondents, have completely disregarded the applicant's right to privacy, human dignity, and basic education in terms of Section 14, 10, and 29 of the Constitution of South Africa by conducting searches on him and his belongings and suspending the applicant. We submit that the respondents have also violated the right of freedom of expression, the right to assembly, demonstration, picket, and petition. They violated the right to freedom of association of the learners that led and took part in the protest of Section 16, 17, and 18 of the Constitution by having them arrested and suspending the applicants from attending classes. As counsels of the applicants, we are also going to show the court how the respondents have completely disregarded and not followed the law as conducted by the South Africa School Act, which should have been their guideline from the beginning on how to solve matters of an educational facility. Your justices, maybe the respondents have forgotten this, but we would like to remind them that South Africa is a democratic country with a fully fledged constitution and the Bill of Rights. This gives guidelines on how her citizens are ought to be treated. There is no one above or below this. Everyone expects to be treated the same. But
sorry, Speaker, if I may interject, if you say that no one is above or below this, what do you mean with that statement in respect of the Constitution?
Everyone must be treated the same, and they expect to be treated the same. But with the case of Mjondolo Combined School, the applicants were not treated the same.
No, Speaker, what I'm trying to ask is your understanding of the Constitution and its authority in the country. Where does it lie in compared to other legislation? Is it the supreme law? Is it below other legislation? Is it subject to other legislation? What is your understanding in respect of the Constitution of the country?
What I understand with this allocation is that everyone has equal rights in this country of South Africa. Now, when it comes to the behavior of how this thing of how the respondents have treated the applicants, it was wrong, and it almost was like they didn't take their rights into consideration.
So if you're saying they didn't take their rights into consideration, okay, so they were not treating the Constitution. So the Constitution in our country is a supreme law, right? It's a law above all other law. It's above all other legislation. So are you saying that they were not giving it the authority that they should have been doing? So
yes, they didn't.
Okay,
they
thank
didn't
you.
at all. Yes, if the court pleases, I may continue. Everyone has the right to education, the right to privacy, human dignity, freedom of expression, the right to assembly, demonstration, picket and petition, and the right to freedom of association. This is stated in section 29, 14, 10, 17, and 18 of the Constitution of South Africa. But the councils of the respondents have completely overlooked this. They not only overlooked this, but they went on to violate them. All institutions, educational or otherwise, need to have guidelines on the behavior of those within its premises. But at no point should these guidelines be a threat to anyone. Mjondolo Combined School has such guidelines that they are set on unfound grounds. They are unrealistic, and most importantly, they are against the institution of South Africa. They are an infringement on the rights of the applicants. Although the school has rules,
speaker for the applicant, if you're saying that they are unreasonable, and you're saying that, why are you saying that they are unreasonable?
They are unreasonable because to take away a child's cell phone, where else, okay, to take away a child's cell phone, where else you know that this child might need this phone for some kind of emergency, was not right. So to take the children to get the children arrested, or rather suspending them, it was wrong. And what reasons was there to arrest these kids?
And speaker, for the applicant, are you saying that there is perhaps an alternative punishment? Can you perhaps suggest an alternative punishment? I know currently the students are being suspended.
Definitely.
Are you saying that there is something less severe? What would that be, for example?
Yes. A suspension of 1 year is a lot. It's harsh. They shouldn't do that. And then, considering that they are pre-matriculants, they will be taking away 1 year, that whole 1 year away from them. So now they will have to repeat that 1 year. Instead of the next year, they could have gone to matric. It was harsh. They could have just made it maybe a year, actually a week, so that they can show the kids we are serious about this suspension thing. But then they went on to just suspend them for 1 year without any notice, without any warning, without anything.
Okay, thank you. Thank you. You may proceed.
Yes. Although the school has the rights that governs its functionality, they clearly violated section 29, 14, 10, and 17 of the Constitution. The school and the SGB has contradicted the Constitution, has violated basic human rights, and has not taken into consideration the South African School Act by suspending the applicants and preventing them from peaceful raising their concerns about the school's action freely. Your justices, the respondents, even after listening to the applicants' reasons that the cell phone was not in use and that the school's code of conduct does not mention a cell phone being in possession, but only the use of the cell phones, they continue to take an unconstitutional decision, a decision to suspend the applicants because apparently he has failed to adhere to the school's code of conduct. They deliberately disregarded the applicants. They treated them as second or third class citizens of South Africa. They disregarded the country's constitution by conducting unlawful searches on the learners, infringing their rights to privacy, human dignity in terms of section 14 and 10. In terms of section 29, subsection 1 of the Constitution of South Africa, the suspension of the applicants by Mjondolo Combined School and the SGB is indeed a violation to the right to basic education. The suspension is a failed attempt to adhere to Section 5, subsection 1 of the School's Code of Conduct, which stipulates that a public school must admit learners and serve their educational requirements. And Section 9, subsection A, which states that a public school may only suspend a learner as a correctional measure for a period of 1 week, which wasn't the case. The applicant has lost and will continue to lose valuable time on his education while he is under suspension, and for this we submit that the school has not completed the Constitution of the South Africa School Act and has wrongfully suspended the applicants. Suspending the learners from school is limiting access to education, therefore in damaging their future. We submit that the respondents have gravely violated his right to basic education in terms of Section 29 of the Constitution of South Africa, because according to Section 29, everyone has the right to basic education. But that has not been the case according to the actions of the respondents. They have denied him his right when they chose to use the most important, chose to alter Section 4 of the School's Code of Conduct of conducting as a basic to suspend him. Your Justices, we are also going to...
Sorry, may I pose a question to you? You were saying that with the suspension, there's been an infringement of the applicant's rights to basic education. But what about the argument that your fellow colleagues may make to say that when the applicants were staging this protest and blocking the road and all sorts of things going on, that they were in fact infringing the other students' rights to basic education because of the fact that they could not get to school and they could not get access to school, and school did not, the teachers went home, everyone went home, school did not proceed on that day. So what would you say in response to that argument?
I would say that they were having a peaceful assembly, but they were prevented from having a peaceful assembly. So for this, I would say that they never wanted to hurt or damage or actually to harm anybody. They didn't want to take anybody's right away from them. So that is why they did it when there was no one around them. So when I get to be asked that question, I will tell them they were just voicing out their voice, voicing out their pain and their concern about the judgment rather on how they were judged on the cell phone issue over here.
Thank you. Thank you.
Thank you. The question that should be asked to the respondents is that in this case, whether the prohibition of the learners from attending classes is aimed promoting peaceful discipline and accomplishment at the school or not, whether the decision passed by the SGB is aimed at educating the learners about the fact that their rights as citizens of this country go hand in hand with the responsibilities. If it pleases the court, may I hand it over to my counsel?
Yes, thank you.
Greetings. If it pleases the court, Your Justice, we would like to put forward that this case requests a spirit of mutual understanding, respect, tolerance, and reconciliation. This case should be resolved harmoniously and not leave any parties involved with bitter taste that could potentially damage their reputation. When a child misbehaves or does not follow rules, appropriate punishment is necessary, but calling the police on underage learners is definitely not a way to go teaching the children manners. It is pure intimidation. It is uncalled. It is showing that the school does not regard the learners as their children, but hardcore criminals that deserve imprisonment. Your justices, we, the counsels of the applicants, have shown that the applicants have behaved in an unfair and unlawful manner. From the facts mentioned, the applicants' counsel has shown that the applicants' right to freedom of expression, freedom of equality, a basic education, freedom of human dignity, the applicant's freedom of speech and freedom of association, and the applicant's right to assembly, demonstration, picket, and petition have been gravely violated by the respondent. We request that the respondent accept the unfair and wrongfulness of their actions and grant an exception which will respect the applicant's rights. This should be done in a way that will respect the school code of conduct, but also not violate the rights.
Sorry, if you're saying that you're asking for an exception. So what relief exactly are you asking for your clients before this court? What would you want for your clients, ideally, if everything goes according to your way and everyone agrees with your argument? What would you want for your clients?
I request that our applicants go back to class immediately.
Okay. And their disciplinary records and that, would you want that cleared, or you just want them to go back to school?
Clear.
Okay.
Yeah, classes immediately.
Thank you.
Okay. This should be done in a way that will respect the school code of conduct, but also not violate the rights of the applicant, as was denied previously. Your justices, we are deemed with equal and should be treated equally with dignity and respect, while having our dignity respected and protected. This has not been the case in the case that we present in court. The applicants have been treated differently. They were punished, suspended, shunned, and made to feel ashamed of having differences of opinion and choosing to speak out on the different unlawful practices of the school. We submit that section 9, 10, and 14, the right to equality and human dignity and privacy respectively, have been violated, and that the applicants were treated unfairly. We furthermore want to highlight section 19 of the South African School Act about the school governing bodies and their functions in the institution. The section provides that the SGB must, in the governance and ruling, always promote the best interests of the school and learners and strive to ensure its development through provision of quality education for all learners. Your justices, we hereby submit that the respondent needs to compromise and make an exception for the applicant by revising and lifting the suspension. We are pleading this because when we look at the school code of conduct, we found that the school code of conduct does not make a provision for any incident where the cell phone is not in use. It only says no cell phone. Therefore, it needs to be revised, refreshed, and restructured to suit all occurrences revolving the electronic devices. And it should be restructured in light of the Constitution's right of the Republic of South Africa, which will ensure that no other individual will go through the uncomfortable random searches that will be invading their privacy.
Speaker 2, how you're saying that you would like that policy to be restructured, right? That's what my understanding is of what you just said. How would you suggest that it be restructured?
I suggest it should be a different punishment, or they should give warnings before the suspension.
Are you just taking an issue with, Speaker 2, are you just taking an issue with the punishment and the suspension, or are you or are you saying that there should be the whole cell phone policy itself should be restructured in such a way that cell phones should in fact be allowed on the school grounds? What is your view on that when you say a restructuring of the policy?
Yes, Your Justice. Cell phones should be allowed, but not in classes. Maybe if a learner brings a cell phone to school, should immediately take it to class. If or the teacher, if the learner, only the learner should have a valid reason for bringing a cell phone to school, and the suspension of the children should be restructured.
Okay, thank you.
If I may proceed.
You may proceed, thank you.
As counsels of the applicant, respectfully request that this honorable court declares that the SGB's ruling and actions were incorrect and unconstitutional, and they have violated the learner's right to privacy and a basic education in terms of Section 14 and 29 of the Constitution. To rule that the SGB's decision is unconstitutional, as it violates the learner's right to assembly in terms of Section 17 of the Constitution, and that all 6 learners should resume to classes immediately. To instruct the SGB, together with the student representative councils and parents, to convene a meeting to re-examine Section 4 of the School Code of Conduct and adjust its context accordingly, so it will be clear, concise, and not give any room for any misinterpretation as it has in this case. Thank you.
Counsel, in the beginning of your submissions, you stated that the police involvement was wrong because they did not treat the learners as children. So is the fact that the arrested learners were later released to the care of their parents and referred to a diversion program not something to be considered?
Pardon?
So the second speaker for the respondent in the beginning of her submission said that the police involvement, right, with the students who were protesting did not show any care to the students being treated as children. So my question is, does the fact that those arrested students were later released to the care of their parents and referred to a diversion program not show that they are being treated as children and allowed a chance not to be imprisoned?
I think the learners should not be in prison, as well stated that they are underage learners, and that I don't think that the parents knew about the unconstitutional situations that were happening in the school. Thank you.
Okay, thank you.
And that will be all from us. Thank you.
Sorry. Thank you very much, team, for the applicant. We can thank you for your arguments. We can move on to the team for the respondent. Thank you.
Honorable Justice, coordinators, teachers, and learners, I greet you all. Looking at the case study, we find that Mjondolo Combined School is a school that lacked discipline, which was something crucial in order to observe positive change, of which is why the new principal had to introduce Section 4 Code of Conduct, which I believe is very constitutional. Is Section 4 of Schools Code of Conduct unconstitutional? My opponent emphasized the right to basic education being violated. Honorable Justice, Section 29 does in fact state that everyone has the right to basic education. This basic right is a sole motive as to why the school decided to introduce Section 4 Code of Conduct in the school, which states that the use of cell phones, whether on or off, by school learners on school premises, shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that cell phone confiscated and may be suspended. This is because the use of cell phones is disruptive and unsettles subsection 29.
Speaker for the respondent, sorry, I don't want to be too hard on you because I know that you're alone and you're missing your fellow speaker today. But just to pose a question to you, I'm sure you've probably heard the arguments that have been made by the applicant. And they are saying that there are less harsh ways in which you can punish students, firstly, who bring cell phones to school. Do you agree with that? Do you agree with that it's perhaps too severe to suspend them for such a long period of time? And if so, what would you think would be a proper alternative way to punish them? Or do you believe that the punishment is suitable?
Honorable Justice, I believe that the punishment is suitable. If the punishment was too severe, it was going to only if there was no warning given to the learners. As we all know that the school has the constitution and it has the rules, and the school has the rules of its own, of which the constitution allows that. This Section 4 Code of Conduct was approved by the learners and the parents.
Okay, thank you. And just on another note, do you perhaps feel that there is merit in the argument that was made that learners bring their cell phones to school, perhaps for an emergency situation? So would you be of the view that perhaps not allowing them to bring it to school at all is unreasonable? Would it perhaps is there perhaps a more reasonable alternative? Like, for example, asking them to hand in their cell phones with the teacher in the beginning of the class? I mean, what would your view be on that in respect of that comment?
The use of cell phones in school premises is disruptive for each and every learner. So I will recommend that if there is an emergency situation, the learners should report to the teachers. As per my knowledge, I understand that each and every school has the school phone, or should I say it has the school equipment, which is used in such situations.
Thank you. You may proceed.
The school in this case is merely ensuring that that right is in fact observed by eliminating a source of disruption to conducive teaching and learning. Subsection 1 of South African Schools Act 84 of 1976 states that, subject to an applicable provincial law, a governing body of the school must adopt a code of conduct after consultation with the learners, the parents, and the educators of the school, which in this case, the Mjondolo Combined School has the code of conduct adopted and in place. Subsection 2 of Section 8 further states that a code of conduct referred to in subsection 1 must be aimed at establishing a purposeful and disciplined school environment dedicated to the improvement and the maintenance of the quality of the learning process. On Section 4 of this Act, it states that nothing contained in this Act exempts a learner from the obligation to comply with this code of conduct attended by such a learner. In our view, Honorable Justice, the code of conduct is not unconstitutional as it justifies the purpose of the learners being at school. What does the Constitution say about the right to privacy?
My opponent emphasized the right to privacy being violated. But Honorable Justice, bear in mind that the Constitution under Section 14 states that everyone has the right to privacy, but on any right that should be observed. Section 36 puts an emphasis on the limitation of the right and states that the rights in the Bill of Rights may be limited only in terms of general law of application, to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom.
Speaker, sorry to interject, and you believe that that what the school is doing is a justifiable and a reasonable limitation?
Yes, it is justifiable and a reasonable one.
Okay, thank you.
Taking into account the nature of the right, the importance of the purpose of the limitation, the relationship between the purpose and the limitation, the nature and the extent of the limitation, and the less restrictive means to achieve the purpose. In the case of Mjondolo Combined School, the right to privacy has limitations as there is. First, a great importance to limit the right in order to serve the purpose of conducive teaching and learning. And secondly, there is a great relationship between the limitation and its purpose. Honorable Justice, in this case, we are faced with two competing rights, which is the right to education and the right to privacy. We are therefore compelled to look at the context of this case. The basic reason for the school environment is to provide the right to basic education. And so this right outweighs the right to privacy. Section 10 states that everyone has inherent dignity and the right to have their dignity respected and protected. Therefore, the applicants, which are the learners, did not show respect upon the dignity of the school. They tarnished the school's dignity by putting out fire on the administration block of the school. The opponent has even went further to disrupting Section 9, which is in respect of equality. As we all know, some students are from families which are financially unstable and cannot afford to buy cell phones. Therefore, seeing other students on their phones could pressurize them and they could end up doing risky behaviors which could lead to them destroying their future.
Sorry, Speaker, I just want to can I just go back to that argument? So you are saying that the students with cell phones are infringing the right to equality for the students without cell phones. Am I following your argument correctly?
Yes. Please rephrase that question.
I'm saying you're making the point that the students that have cell phones, right? You referred us to Section 9 of the Constitution, which is the right to equality. Are you saying that the students who do have cell phones, are they infringing the right to equality of the other students who do not have cell phones? Am I understanding your argument correctly?
Yes, they are.
And how are they doing that?
If we allow cell phones at school, we are inevitably forcing financially disadvantaged learners to resort into crime and unjust behaviors in order to level up with the new normal of showing off.
Okay, thank you. You may proceed.
Honorable Justice, schools need uniformity, and that uniformity should be prescribed by the school in conjunction with the school governing body in order to ensure equality amongst learners. The applicant, which are the learners, have even went further to violating the protocols of Section 3. They did not provide the Mjondolo Combined School and the police with a notice as per the Constitution. Therefore, Section 12 of offences and penalties must apply, of which state that any person who convenes a gathering of which no notice
or no adequate notice was given, that person shall be guilty of a crime and on conviction liable in a contravention referred to A, to a fine, B, to imprisonment, or to both such fine and such imprisonment. Furthermore, Honorable Justice, Section 13 under the interpretation of this Act, furthermore, Section 13 under the interpretation of this Act state that the provision of this Act shall not be construed as to detract from A, Control to Access to Public Premises 1985 and Vehicles Act, which is Act 53 of 1985, or B, Criminal Procedure Act 1977, which is Act 51 of 1977, or C, the right of any person regarding self-defense, necessity, and protection of property, of which in the case of Mjondolo Combined School, when the learners protested, they violated this act. First, they set the school's administration block on fire. And secondly, they set the rubbish bins on fire. Thirdly, they prohibited the learners from accessing the public premise, which is the school. To ascertain the issue, they did not put in a notice, making the protest illegal. Is the SGP's decision unconstitutional? This court needs to understand that the SGP's decision is very much constitutional. Hence, looking at the following case, it is evident that the school had the right to take such decisions in order to instill discipline in school, which was the case in Mjondolo Combined School. Honorable Justice, even in the case which was held at the High Court of South Africa, Eastern Cape Division, case number 45408 of the learners who misbehaved towards the school master, the court ruled in favor of that particular school. This judgment that I have quoted supports my argument. As I am concluding, Honorable Justice, this court needs to acknowledge that learners need to understand the school environment and its demands. Some rights can never be prioritized in the wrong context. And in this case, the learners that are fought for by the learners can never compete with the fundamental right to education that is fought for by the school.
Speaker 2, sorry, you are running out of time. Can I ask that you please finish up for us? Thank you.
Honorable Justice, discipline is necessary to promote good quality of education. And that is all from me today.
Thank you very much. The applicant, do you have a rebuttal that you would like to share? Okay. I'm going to give you, 2 minutes for the rebuttal. We are unfortunately running slightly late, and I know some of the adjudicators are needed in the next session. So would that be possible for you to do that in 2 minutes?
Yes, it will be, Justice.
Thank you. Then please proceed. Thank you.
The SGB's ruling was not unconstitutional and did not violate learners' right to peaceful assembly. That's what the applicant, the respondent is saying. Then what did it do if it did not do all of these that is above? If they are saying that the ruling of the previous ruling of the High Court must not be changed, but the applicant's claims were found, the applicants were following the rules of Mjondolo Combined School as educational institution. So why did the ruling against our clients, why shouldn't it be changed? If they're saying that our clients set the school on fire, where is the evidence? Yes, the applicant signed the school's code of conduct, and therefore before signing it, they read it, of course. But in the right mind of a person that's old and matured enough, who would sign a paper that is strictly saying that you will be suspended for a whole year? Who would want to put their education at risk like that? So obviously they were blindsided. So for that, the applicants submitted themselves to be governed by the school's code of conduct. So why did they all of a sudden choose to not submit themselves to it? Why would they disrupt its laws on purpose? Don't you think that they were cheated somehow, or rather they were blindsided? Because if you if you submit yourself to something and then you suddenly change your mind about it, or rather go on a different angle about it, it means something was wrong. So they signed the paper. After signing the paper, they all of a sudden heard that the cell phones were not allowed at school, and then after that they will have to be suspended for the whole year. But they wouldn't have signed a paper if that was in the paper. So it was wrong, and there's no evidence stating that my clients over here set the school on fire. They were just having a peaceful protest outside the school, not in the aim of harming anyone or harming anything. Thank you.
Thank you very much. Thank you very much, team, for the applicant and the respondent. I am aware time-wise that the next session is running slightly late, but I do not want to take away from your experience. So I would like to just find out each of my colleagues and my co-justices, would you like to provide very brief feedback to each of the teams, if you would feel comfortable in doing so? Then I ask that we just one or two lines maybe of your views, or perhaps some tips for the speakers going forward.
Yeah, sure. I can go first. Can you all hear me?
Yes, we can. Thank you.
Because I've been having connectivity problems. I think both teams spoke well. For me, just going forward, I think it's important to listen to each other when the other team is making submissions. And then I think after hearing the other team's submission, if you really feel strongly about the other team's submission, or you have something to answer straight into that, you incorporate that into your argument. I think that's important, but I think that both teams spoke very well, and that's all I have to add.
I would like to agree with what Justice Bilankulu just said. They spoke well, and it showed great preparation, and overall, good luck going forward in the competition.
Thank you very much. I would just like to say well done to everyone. I think everyone was fantastic. I think especially our speaker from our respondent team, who was very brave, speaking all by herself today. I know that can be very daunting. So well done to everyone. I would also say going forward, perhaps just if you are asked questions, don't feel intimidated by it. It's a good sign if your justices are asking you questions, because that means that they are listening to your arguments and they're engaging with your arguments. So they want to hear your views, and perhaps they want to ask you some extra questions. And that's a good thing, because that means that they're following your arguments. So I would suggest that you listen carefully to the questions. If you require a bit more clarity, you can ask them maybe to rephrase, and that you try and answer it as best as you can, even if it's not 100% answer, but you do try and make an attempt to answer it, because I think that shows that you are engaging with the judge, which is important. But other than that, I think everyone was brilliant, and I wish you the best of luck for the competition going forward. And on that note, the session 8 will be dismissed. Can I please ask that those that is not in the next session, if they could please leave the room. I don't know my adjudicators, whether they will be joining me for session 9. If not, if I ask to please that you also exit, so that I can allow the next groups in for session 9. Thank you very much. Everyone, again, apologies for the delay. My name is Trisha. I will be presiding over today's hearing. Thank you very much for joining us, and apologies for the delay. I think given the fact that there is a slight delay already, I'm going to ask if we could please go ahead and start. I think perhaps just if each of my co-justices would be willing just to briefly introduce themselves, put on their camera, say hello to each of the teams. And then I would ask if the applicant team can be on standby. And if I can ask each of the teams, please just to introduce themselves before they start speaking. But if we can quickly just give each of the justices an opportunity to say hello and just to introduce themselves to everyone. Thank you.
Hello, everyone. My name is Homela Letswalo, and I will be one of the justices adjudicating this particular session today. And it's great to have you here. Thank you.
Hi, everyone. My name is Precious Mutokwani. I'm a final year LB student, and I'm going to be one of the justices for today.
Thank you very much, colleagues. If I can then turn to the applicant team, applicants, if you can please introduce yourself before you start with your arguments, switch on your camera, and then you may proceed. Thank you.
Justices, my name is Tibakone Letabo, and to my left is Ms. Malalota Netsofat.
Thank you. You may proceed. You may start. Thank you.
As it pleases the court, my name is Tibakone Letabo, and I appeal with my co-counsel, Ms. Malalota Netsofat, and we appear on behalf of the applicant in this matter. From the time provided, I will be speaking for 9 minutes and my co-counsel for 8, and we have reserved 3 minutes for rebuttal. My honorable justices, this is an application for a declaratory order in the matter between the 6 learners of Mjondolo Combined School, namely 14-year-old Mbali, 15-year-old Crystal, 16-year-old Apiwe and Precious, 17-year-old Tabo and Eddie, being the applicant in this matter, and the respondent being the public school of Mjondolo Combined. Justices, this matter concerns the incident that took place at the public school of Mjondolo Combined School in Bramfontein in the Gauteng province. As it pleases the court, I would like to give a brief summary of the facts in this matter. The facts are as follows. For a number of years, the public school of Mjondolo Combined School has encountered a problem with discipline and a high incidence of absenteeism among learners and teachers alike. As a result, in the year 2018, the matric pass rate achieved was only 53%. And in the year 2019, Mrs. Kosa was then appointed as the new head of the school, and then discipline was birthed to the school. The matric pass rate achieved was only has dramatically increased to 72%. Thereafter, the school governing body decided to introduce a code of conduct that regulated the use of cell phones at school. The code was then adopted and immediately implemented. Sfiso Tele is 17 years old and in grade 11. One morning, while in class, his cell phone drops out of his pocket. His teacher, Mr. Mkize, sees it and immediately confiscates it. Sfiso undergoes a disciplinary hearing that results to his suspension for the rest of the year. Thereafter, the principal ordered a search of the bags of all learners, of which 6 cell phones were found. The 6 pupils who were found in possession of those cell phones were then suspended for the rest of the year as well. If it pleases this honorable court, I would like to begin with issue 1 in this matter.
Yes, please proceed. Thank you.
Issue 1 primarily regards the unconstitutionality of Section 4 of the School Code of Conduct, as it violates the learner's right to privacy in terms of Section 14 of the South African Constitution. After the principal ordered a search of the bags of all learners, 6 cell phones were found, and the learners were suspended for the rest of the year. The Act is seen as a clear violation of the appellant's right to privacy under Section 14 of the Constitution, because it states that everyone has the right to privacy, which includes the right not to have their person or home searched, their properties searched, their possessions seized, or the privacy of their communications infringed. But however, the principal, being in accordance with Section 4 of the School Code of Conduct, went ahead to violate one of the appellant's right. I would like to bring to this court's attention the fact that the bags of the learners in this matter are regarded as their personal properties, of which the principal ordered a search of those bags. This act is then seen as a clear violation of the appellant's right not to have their properties searched. Justices, it is clear that under Section 28, subsection 2 of the Constitution, it is well established that...
You speak of the appellant's right to privacy. Can the right to privacy be in any way limited?
Yes, it may be limited, but only under law of general application.
Under what authority and where can we find that?
At the school or in other public
of the law of in which we limit such right to privacy. Where can we find it?
We can find that under Section 36 of the Constitution.
Thank you.
As it pleases the court, I would like to continue with the presentation.
Speakers, may I ask, please feel free to continue speaking after questions have been asked. If any of my colleagues have any further questions, they will certainly ask you, or they will continue with the train of questioning, but you can just proceed without having to ask to do so. Thank you.
Thank you, my Justice. Section 28, subsection 2 of the Constitution speaks on behalf of the learners, as it cites that a child's best interests are of paramount importance in every matter concerning the child. It is also in confluence with Section 28, subsection 3 of the Constitution, which states that in this section, child means a person who is under the age of 18. I would like to bring to this court's attention the fact that as I open to this discussion or this argument, it appears very clearly that all the 6 learners are under the age of 18. This is adequate evidence presented before this court that Section 4 of the School Code of Conduct has been inconsistent with Section 14 of the Constitution and with Section 28, subsection 2 and Section 28, subsection 3 of the South African Constitution. I would like to bring to this court's attention the definition of the term unconstitutional, which defines contrary...
Speaker, sorry. Why would you say what the school is doing, in your own words, how is it infringed? Which aspect of what the school is doing or what they did would you say is an infringement of the rights of the children?
Them having to search the bags of the learners.
Is that the only aspect that you believe is infringing the rights of the children?
Yes, ma'am.
Okay, thank you.
This is adequate evidence presented before the court that shows that Section 4 of the Code of Conduct clearly violated the appellant's right to privacy. We humbly request this honorable court to call the attention upon the definition of unconstitutionality, which defines contrary to or violation of the constitution of a state or other sovereign institution. We submit that the court bases its decision upon Section 2 of the Constitution, which calls for the supremacy of the Constitution. It is by
Sorry, Speaker, if I may ask, what do you understand as under the supremacy of the Constitution? What does that mean to you?
It means that the Constitution is the supreme law of the land, and that any other law that is found to be inconsistent with the Constitution shall be declared invalid, and may, amongst other remedies, be amended.
Thank you.
It is by our argument that we respectfully request this honorable court to notice the clear violation of the appellant's right to privacy, to declare Section 4 of the Constitution of the Code of Conduct unconstitutional, and to lastly rule in favor of the applicant. If it pleases the court, I would like to begin on issue 2 in this matter.
Yes, accept. Please proceed. Thank you.
Issue 2 primarily regards the unconstitutionality of Section 4 of the School Code of Conduct as it violates the learner's right to basic education. Section 29 of the Constitution guarantees everyone the right to a basic education regardless of external means. The right to a basic education is recognized as an absolute right. This means that no one may be refused of this right. It is established that absolute rights are not subject to any form of limitation or qualifications in our country. The suspension of the learners from the school is hereby seen as a clear violation of the appellant's right under Section 29, subsection 1A of the Constitution, because the suspended pupils were deprived the freedom to exercise their right under Section 29 of the Constitution, as they had to stay home for the rest of the year. Suspension is hereby seen as a harsh and extensive punishment that fails to harmonize or balance the extent of the offense committed.
Speaker, may I ask, you say that it's harsh. And so I assume that you're suggesting that there may be a less severe form of punishment. What would you suggest, what in your mind would be a less harsh and more reasonable punishment in respect of what the pupils have done?
Justice's other less restrictive means include the calling of parents or detention after school.
Thank you.
It is without any doubt that the Code of Conduct focused too broadly on discipline and disregarded the fact that education is also seen as a legitimate goal for both the public school of Mjondolo Combined School and the best interest of the child. This is in contrary with paragraph 98 of the Pillay case that was handled by the Constitutional Court of South Africa, which states that both discipline and education are legitimate goals. However, care must be taken not to state the school's interest too broadly. This act is also in contrary with paragraph 58 of the Head of Department of Education versus Belcom High School case that was handled also by the Constitutional Court of South Africa, which stated that a code must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. It is also clear that the suspension of the learners was very much unlawful because under the South African School Act 84 of 1996, Section 9, that deals with the suspension and expulsion from public schools, subsection 1A, it is stated that subject to the South African Schools Act and any applicable provincial law, the governing body of a public school may, after a fair hearing, suspend a learner from attending the school as a correctional measure for a period not longer than a week. This is seen as unlawful because there was no fair hearing and there was no disciplinary hearing as the suspension was immediate. This is clear that the sanction was not corrective, but rather punitive in this matter. As it pleases the court, I would like to proceed.
Yes, please proceed, speakers. Please go ahead and continue. Thank you.
From the council's view, the adopted code undoubtedly instilled great discipline, but as a consequence, it led to the violation of the appellant's right to basic education, of which the code failed to maintain the quality of the learning processes as learners had to stay home. It is clear and evident enough that Section 4 of the School Code of Conduct is inconsistent with Section 29, subsection 1A of the Constitution, and Section 9, subsection 1A of the School Gatherings Act 84 of 1996, and the supreme law of the land as well. Therefore, counsel for the applicant submits that this honorable court should notice the unlawfulness of the code, to notice that the appellant's right to basic education was infringed, and to lastly declare Section 4 of the Code of Conduct unconstitutional as it had violated the learner's right to basic education. If it pleases the court, I would now like to hand over to my co-counsel who will be dealing with issue 3 in this matter.
Justices, my co-counsel has tackled the first 2 issues the applicant has brought to this court. They are, number 1, the unconstitutionality of Section 4 of the Code of Conduct and its violation of the applicant's right to basic education. And secondly, the unconstitutionality of Section 4 of the School Code of Conduct and its violation of the applicant's right to privacy. Therefore, I have one submission to make, which exclusively deals with the unconstitutionality of the school governing body's verdict and how it infringes the applicant's right to peaceful assembly in terms of Section 17 of the Bill of Rights of the South African Constitution. Prior to our argument, we would like to put forward once again the fundamental law that our argument for the violation of the applicant's right to assemble, demonstrate, picket, and present petition will be based upon. That is, the Constitution is the supreme law of the land. Any other law that is inconsistent with the Constitution must be declared invalid and may, amongst other remedies, be amended. If it pleases the court, I would now like to begin with the third and final submission. It was cited in Article 15, subsection 1 of the United Nations Convention on the Rights of the Child that state parties recognize the rights of the child to freedom of association and to freedom of peaceful assembly. And as South Africa has agreed to be bound by the UN Proviso, Section 17 of the Bill of Rights states that everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket, and to present petitions.
Sorry, if I may interject. Do our South African courts, do we have a duty to consider foreign conventions and foreign jurisdictions and foreign jurisprudence?
Yes, Your Justice. It was cited that it was cited that South Africa has signed a treaty to be bound by the provisions of international law. Therefore, they are considered when the Constitution was made. It is of paramount importance, Honorable Justices, that we take into consideration that the protest was carried out by minors who were concerned about the decisions being made by the SGB and the school that did not have their best interests at heart. After the 6 students that had their cell phones confiscated by the school, they had their frustrations building up. But because they are not of adequate power and voice as the school and the SGB, the only outlet they had available was to present petition in a peaceful, unarmed assembly for a very lawful purpose. This is in accordance with paragraph 61 of the Garvers case, which provides that, and I quote, "The right to assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless. This includes groups that do not have economic or political power and other vulnerable persons. It provides an outlet for their frustrations." There was no other way that the applicant could voice their opinions. Mjondolo Combined School is a school that uses corporal punishment, and as the 6 students were minors, they feared that. Counsel for the applicant finds the decision of the SGB unconstitutional, as even the principal herself took into consideration and accepted the fact that learners do have the right to raise complaints.
Counsel?
What reasons? Yes, Your Justice.
Considering the facts as set out, would you say that the students indeed took on a peaceful protest?
Yes, Your Justice. The protest was indeed peaceful.
What about when the school entrance was blocked with bins and later the fire that was set? Was that still part of the peaceful protest?
Yes, Your Honor. They did not inflict violence or pain on any of the participants or any of the students who wanted to enter the school premises.
But sorry, if I may follow from my, colleague, are you, sorry to interject. Do you have a follow-up question?
No, you may continue.
I think following from my colleague is trying to say, you're saying that they did not interfere, but we know for a fact from the fact sheet if I recall correctly, that because they were blocking the road, the other learners could not attend school that day. And in fact, school did not proceed that day. So what I'm trying to put to you is we've got two rights here that are competing with each other. We've got your client's rights to freedom of expression and freedom and their right to protest, but we also have the right to basic education of the other learners. So how do you compare those two? Because you just commented and said no, that they could go to school, but in fact, we know from the facts that that's not true.
The Justice, the learners convened outside school premises, and the school being closed was not because of them. If it please the court, I would now like to proceed with my submission.
And sorry, what is your view on the two competing interests though? Because obviously whenever there are competing interests, one needs to weigh these interests and ultimately decide which one is more important and more supreme in the end of the day. And then according to your argument, would that be the rights of your clients or would that be the rights of the applicants? Would that be the rights to protest and to have freedom of expression? Or would that be the many other learners' right to basic education, which was being infringed on that day because they couldn't go to school?
It would be the applicants' right to protest, as they were raising complaints that the other students could not raise complaints on. They raised the complaints due to the discipline that was being inflicted on the school that was not in any way positive. The school used corporal punishment, the school used banner on cell phones, and furthermore, they suspended students for the maximum period of time.
So are you saying that your clients were in fact not just protesting on their own behalf, but also on behalf of the other learners? Is that what you're trying to convey?
Yes, Your Justice.
Okay, thank you.
What raises eyebrows and makes us question the constitutionality of the SGB is that who was present at the urgent meeting that was held. It is vivid that the SGB did not follow the correct procedures when suspending the applicant. There is no mention of the parents being called or the students being given a fair opportunity for their side of the story to be heard. The SGB made the verdict on their own. The unconstitutionality of the SGB's decision lies in the fact that they govern a school that has rules inconsistent with the Constitution of the Republic of South Africa. Corporal punishment and suspending students for an unknown period of time is an example of such. And in this matter, taking away an inalienable right of the applicant to protest. The suspension of the 6 students is based primarily on the fact that they were merely carrying out their rights to protest. It displays a total repression of freedom of expression through protest and demonstration. This was a norm under apartheid, whereby, and I quote, a state would take numerous legislative steps to strictly ban public assembly and protest, close quote, as cited in paragraph 62 of the Garvers case. In the case of the SGB, the learners were extensively reprimanded and restrained of their right to assemble by being denied their right to basic education. We submit once again that the exercise of assembling and picketing was the only mechanism available to the learners to help them express their legitimate concerns of the school. The applicant had presented a peaceful and unarmed petition, but the SGB suspended the 6 pupils for a mere fact that they were assembling peacefully, thus putting an unjustifiable limitation to their right to assemble.
Sorry, Speaker 2, I think we're back at the peaceful assembly. I mean, my colleague raised the fact that, let's be honest, the assembly was not so peaceful. So are you persisting with the fact that, in your view, that the gathering was peaceful?
Yes, Your Justice. They did not use any violent materials. We can see this in the example that they only used pins to barricade the road. And when the police told them to disperse, they did so.
Thank you. Thanks.
The only thing that the learners aimed to achieve when presenting their petitions through a protest was to have their voices heard and their demands met. They had no intentions of doing anything detrimental or illicit, thus choosing the setting of the protest to be outside of the school premises and having no relation to the fire that started in the school premises during the protest. According to Section 12, subsection 1A of the Bill of Rights, I quote, "Everyone has the right to freedom and security of the person, which includes the right not to be deprived of freedom arbitrarily or without just cause." The school governing body took extensive measures when reacting to the protest by the learners, so much so that they violated that Clause 12 right. The unjustifiable limitation and violation of the learners' right to peaceful assembly by the SGB's verdict acts inconsistently with the supreme law of the land and should therefore be declared invalid and unconstitutional. In cessation of our argument, counsel for the applicant has prevailed that Section 4 of the School Code of Conduct is unconstitutional, and it violates the learners' rights to privacy, basic education, and peace, and the right to picket. Furthermore, we have provided this honorable court with substantial information that the applicant's right to peaceful assembly was violated by the SGB's settlement. Therefore, counsel for the applicant courteously submits to this honorable court to rule in favor of the applicant and to declare Section 4 of the School Code of Conduct unconstitutional. If it pleases the court, I now wish to take my leave.
Thank you so much. Thank you. I think we can proceed to the respondent team. Thank you.
Honorable Justices, and may I please the court. My name is Kato Bartman. I will be speaking first. My co-counsel's name is Kiara Hendricks. She will be speaking second, and she will be addressing our prayers. Honorable Justices, I will be addressing the first issue in this instant case, which is Section 4 of the School Code of Conduct is not unconstitutional and does not violate the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. The question before the court today is whether the applicant's right to privacy and basic education has been violated by the School Code of Conduct. We submit that the applicant's right to privacy has not been violated, but justifiably limited under Clause 36 of the Constitution of the Republic of South Africa. We submit that the purpose of the limitation is important and it is of the child's best interest under Section 28, subsection 2 of the Constitution. We as the respondent contest that Section 4 of the School Code of Conduct is not unconstitutional because under Sections 8, subsection 2 of the South African School Act 84 of 1996, a code of conduct first must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of quality of the learning process. We submit that the maintenance of the Section 4 of the School Code of Conduct is aimed at establishing a disciplined school environment, but also holds the child's best interest at heart. The learners achieved low pass rate and lacked discipline before the implementation of Section 4 of the School Code of Conduct. And after the effectiveness of the School Code of Conduct, the matric pass rate increased by 19% and 10 learners achieved bachelor passes for the first time. This is to show that the measures that the Code of Conduct implements are of the best and of the learners and school, as it has proven to help the learners.
Speaker one, may I ask that do you not perhaps think that there are less severe ways and less restrictive ways and in forms of punishment that you can provide in which you can still achieve discipline and excellence for the school versus suspension and for extended period of time and taking away cell phones? You know, are you not of the view that there are perhaps a less restrictive way in which you can still achieve your goal?
Justice, we submit that as the respondent, Thus, that this is the less restrictive means that the school has implemented in this instant case, because they cannot use corporal punishment, and also this punishment is proportionate to the violation that the learners has violated. I submit that to this honorable court.
Thank you. Thank you.
Section 4 of the School Code of Conduct states that the use of cell phone, whether on or off, by learners on school premises shall all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended. The applicants argue that that phone confiscated, that this code of conduct violates the learner's right to privacy and basic education in terms of section 14 and 29 of the Constitution. We submit that this is incorrect, as the limitation placed on the code of conduct were urgently and really needed to bring back discipline at school and a purposeful school environment. We also submit that the limitation placed on the code of conduct are justified under section 36 of the Constitution, as it states that the right in the Bill of Rights can be limited only in terms of under law of general application. And we submit to this honorable court that the school code of conduct is implemented as a law of general application, because it applies to all school learners of Mjondolo High School. We also submit, upon amendment of the school code of conduct, the learners, educators, and parents were informed and consulted as stated in the facts that after a consultative process, then the code of conduct was introduced. But we also argue that even the SGP itself is made up of learners, educators, and parents of the learners. So whatever decision they make is law and binding and is made for the best interest of the school and learners. Section 14 and 29 of the
Council,
yes.
do you think that it is in the best interests of the learners for the school to suspend them for a period of up to a year, as in the fact it does mention that Sipho, when his phone was discovered, he was subjected to a hearing and he was suspended for a year. Do you think that is a reasonable suspension period? And is it in the best interests of the learners to suspend them for that long?
My justice will submit as the respondent, it is the best interest of the child to be suspended in that instant case for breaking the school code of conduct. And you also submit, my justice, that they were not suspended for a whole year, but for the rest of the year, as is stated in the facts, that they were only suspended for the rest of the year. And it's not clear whether when were they suspended, because the case, they only state the month of the case, which is October. And the rest of the year, that would mean October, November, and December, which will be 3 months. If that answers my justice's question. Thank you, madam. Sections 14 and 29 of the Constitution are like any right in the Constitution, are not absolute and can justifiably be limited from time to time under law of general application. The right to privacy affords a greater intensity of protection to a person's activities within the sanctum of home. Where individuals engage in communal activities such as education, the intensity of this protection diminishes. And also, this is like airports, justice. If the school therefore decides to search learners in order to prevent dangerous weapons or contraband or any prohibited items being brought onto the school premises, it must do so under law of general application or legislation. The seizure of cell phone was allowed because the school had a policy prohibiting cell phone to school premises, and sections 25 subsection 1 of the Constitution, which is privacy, states that, and I quote, no one may be deprived of property except in terms of law of general application. Hence, the school was justified in confiscating the cell phones. The suspension was to follow because the school code of conduct clearly stated if found in possession of a cell phone, you might be suspended, and that clause was agreed upon by the stakeholders of the school. Furthermore, we submit that the school is justified in limiting the right to basic education. The right in basic education because the learners were clearly warned and consulted and made aware of the prohibition, and the code of conduct is clear and unambiguous, but they thought to bring the cell phone to school anyway, breaking the code of conduct. we submit that they are eligible to punishment for breaching this law. The limitation of the right of basic education is justified under clause 36 of the Constitution. Therefore, the school is justified for suspending the learners for the maximum period, which is the rest of the year. 1 week unconstitutional, but the SGB decision to suspend is unconstitutional under Section 9, subsection 1A of the School Code of Conduct. The governing body can suspend a learner from attending A as a correctional measure for a period no longer than 1 week. We submit that this punishment is proportionate to the offense and act as a measure to discourage learners from bringing cell phone at school. In submutation of arguments, my lord, counsel for the respondent has established that legislation set in place to govern the school is legal and important. The School Code of Conduct aims to establish a school of disciplined learners who strive for excellence to improve and maintain the quality of the learning process and the school environment. Looking at the sections of the School Code of Conduct that the school has relied on for seeing better results, has worked and improved discipline as well as academic achievement, I see no reason for this court to declare it unconstitutional, as it is impossible to use other forms of discipline, as learners have proven to not cooperate. Therefore, the Code of Conduct is necessary to adhere to. If it pleases the court, I would like now to take my leave.
Thank you.
Thank you, my justices.
Following my co-counsel, as it pleases the court, I'd like to begin discussing the next issue. We, as the respondent, have heard the applicant's submissions that the learner's rights to peaceful assembly in terms of Section 17 of the Constitution has been violated, but we submit that this is incorrect because, firstly, according to the regulation of Gatherings Act number 205 of 1993, amongst other things, regulates the holding of public gatherings and demonstrations at certain places. In line with the provisions of Section 17 of the Constitution, its preamble reads, whereas every person has a right to assemble with other persons and to express his views on any matter freely in public, and to enjoy the protection of the state while doing so, and whereas the exercise of such rights shall take place peacefully and with due regard of the rights of others. It has, however, been limited in that if they wanted to protest without giving notice, they could do so, provided they kept their numbers to a maximum of 6. And if they knew that their numbers were going to increase, they needed to give the requisite notice. Section 17 of the Constitution effectively enshrines the national right to protest and distinguishes between 3 such forms, namely assemblies, demonstrations, and pickets. Section 17 reads, everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket, and to present petitions. Like other rights in the Bill of Rights, Section 17 must be balanced against other rights and interests, particularly the right to life, dignity, freedom, and security of the person and property. While Section 17 is automatically subject to the limitations clause contained in Section 36 of the Constitution, the construction of the right includes internal qualifiers to the right to protest. In order to be lawful, a protest must be peaceful and unarmed. In this case, it was not peaceful. It was disruptive because the protest led to confrontation with road users. In terms of Section 12, subsection 1A of the Gatherings Act, it justifiably limits Section 17 of the Constitution. The 6 learners were all presumed to be conveners of the gathering and had failed to give notice of the gathering. And notification of a gathering is important to allow for proper planning. That in terms of the Gatherings Act, is a criminal offense. We therefore submit that attending a gathering that was prohibited because no notice had been given is illegal.
Sorry if I may interject. What if their response was, well, we didn't obtain a notice because it was spontaneous. We didn't really plan it. You know, we felt strongly about it in the moment. And so we all just appeared and other people joined in we couldn't control it. And now there's a protest. What if that was their defense? And that's why they say they didn't get a notice.
My Justice, logically, spontaneity doesn't abide with the results of there could be damage to certain property and certain people and their rights. If that answers my Justice's question.
Thank you.
Stricter rules apply to gatherings. No notice is required for a demonstration, but the convener of a gathering must give written notice to the local municipality, generally 7 days in advance. Rather, the purpose of the notice is to enable the municipality and the convener of the gathering to decide on how to proceed with the gathering. In the eyes of the law, the demonstration quickly became a gathering because a demonstration consists of 15 or fewer participants. In this case, when there were 6, they did not have to give notice. But as soon as the numbers increased and the 10 learners joined, it became a gathering. As well as in the second protest, no notice had been given and there were approximately 100 learners, definitely a gathering. In terms of Section 5 of the Gatherings Act, a gathering may be prevented and prohibited in certain circumstances. This may occur when there's a threat that a proposed gathering will result in serious disruption of vehicle or pedestrian traffic, injury to participants in the gathering or other persons, or extensive damage to property, and that the police and the traffic officers in question will not be able to contain this threat. In this case, when the learners experience confrontation with the road users and the burning of the bins. Secondly, the applicant submitted that the SGB's decision was unconstitutional. We, as counsel for respondent, submit that this is incorrect. The SGB's decision was not unconstitutional because according to Section 4, subsection 2A of the South African School Act, the school governing body may, on reasonable grounds and as a precautionary measure, suspend the learner suspected of serious misconduct from attending school. In this case, the chaos that had begun at the school and the many incidences that could have been seen as dangerous that occurred. The learners blocked the entrance to the school. The school was forced to close, and that's violating many learners' right to learn and to be educated. They prevented the meeting from taking place. They should therefore be punished. In conclusion, the Council for Respondent has established that legislation set in place to govern the school is legal and important. In order to improve and maintain the quality of the learning process and school environment, a code of conduct must be set. Looking at the sections of the Code of Conduct that the school has relied on for seeing results, it is impossible to use other forms of discipline, as the learners have proved to not cooperate prior to the Code of Conduct. Therefore, the Code of Conduct is necessary to adhere to. For our prayers of relief, Counsel for the Respondent respectfully requests this Honourable Court to declare the High Court was correct in finding that there was no violation to right of right to privacy and basic education, as well as right to peaceful assembly, and to rule that the applicant should therefore remain in suspension for the rest of the year. If it pleases the court, I wish to take my leave.
Speaker, if I may ask, since you have so nicely set out the relief that you seek, what relief do you seek in respect of costs for all of this, for the hearing and the council and everyone that's appeared and going to various courts? Who would you like to carry these costs?
Your Justice, the school.
The school?
Oh, sorry, the learners.
Okay. Oh, okay. Thank you so much. Thank you.
Thank you.
Thank you very much, team, for the respondents. Team, for the applicants, you now have 3 minutes for a rebuttal. I'm not sure if you would like to proceed with a rebuttal.
Yes, Your Justice.
Then you may proceed. Thank you.
Justices, counsel for the applicant has 2 points on rebuttal. The first being the fact that the respondent has failed to take into account all relevant factors considered for a justifiable limitation, as cited by Section 36 of the Bill of Rights. There is no way that depriving the pupils their right to education can be seen as a less restrictive way of achieving the purpose of the limitation. The second submission we have to make is that the counsel for the respondent mentioned that the applicant was suspended for 3 months. 3 months extremely shows that the school has failed to follow Section 9, subsection 1A of the Schools Act that says that learners can only be suspended for a maximum period of 1 week. If it pleases the court, I now wish to take my leave.
Counsel, on your rebuttal, I'm going to ask the same question as I asked for the respondents' counsel. Who would you, any prayers in respect of the costs? Who do you feel should be carrying the costs of all of this expensive litigation?
Justices, counsel for the applicant courteously submits and requests this honorable court to rule in favor of the applicant and to declare Section 4 of the School Code of Conduct unconstitutional.
Okay, and if we do that, but the cost aspect, so who, litigation costs a lot of money. So who do you think, if the court rules in favor, theoretically, of the applicant who you are representing, what do you think would be fair? Who should cover these costs for all this litigation?
The respondent, Your Justice.
Thank you. Thank you very much to both teams. If each of my co-justices and my fellow colleagues, I don't know if you would like to, but we are running a bit behind time, but late, but I don't know if you would like to briefly, just 1 or 2 thoughts that you may have, or perhaps provide some feedback that you may have for the excellent speakers that we heard today.
I'll go first. I would like to first start by thanking everyone who made the submissions. I think that everyone was excellent today. All of the arguments being made were very excellent arguments. The questions being answered were great. And I think that something that could be worked on, of course, is how you approach some of the questions. You need to give time to think of the answer first, rather than just, stating it, out same time. It's fine for you to just take a break. Just drink some water and think about the answer so that you provide a more well thought out answer. But otherwise, I thought that everyone was great. Great usage of authority and international law was also considered, and I will conclude.
With my feedback, I'd like to thank the participants for their preparations. It was a nice mood, and also with what my judge has said now, take time to listen to what the question is, and so you can answer properly instead of answering what you think was said So just listen properly. If you don't understand, ask for the question to be restructured. And also there was nice coordination from the speakers, and going forward, good luck.
Thank you very much. I think it was a really exciting moot court session that we had today. So thank you very much for all the participants. And I can see that you guys all spent a lot of time preparing and you put a lot of energy into this. I definitely agree with my colleagues to say that I think you mustn't feel overwhelmed when you get a question from an adjudicator. Receiving a question from an adjudicator is actually a good thing, because it basically shows you that the adjudicator is engaging with you. So they're following your argument, they're asking you follow-up questions. So that means that they're following what you're saying. So I would agree with my colleagues to say that it's a good idea to listen carefully, perhaps take a moment. I don't think any of the adjudicators would blame you if you take a moment to think about what was asked, and then obviously don't stand there for 3 minutes, but take a couple of seconds. If you want to drink some water, give a response. If you don't understand the question, I think ask if they could rephrase it for you, perhaps. And I think it's important to think about the question. And sometimes the question is not written down in your research. Sometimes the question is not written down in your notes. So I know sometimes the first thing that you do is you immediately go and you start searching through your notes for the answers. But sometimes the questions that are asked aren't always theoretical. Some of them are just very sort of practical, following the arguments that the teams have made. So I would suggest that you just listen to them and just answer them, by thinking clearly and logically about them. Secondly, I would also suggest, just to know, going forward, the question of costs may certainly come up again. It's important, and it's a very important prayer. It's as important a prayer as any of the other prayers. And certainly you do not want your clients to be covering all these expensive costs, especially if we went all the way from the High Court to the Constitutional Court. Trust me, that's very pricey. So certainly you would always pray, your prayer would always be for the other party, or the party who is unsuccessful, to cover the costs. So that's maybe just something to note going forward. Perhaps the question does come up again if you do proceed onto the other rounds. But other than that, well done to everyone, and good luck with the rest of the moot. And I hope that you will all enjoy it. And thank you also to my colleagues and my co-justices that assisted today. Thank you very much.